For the court is now in session.
Please be seated.
Madam Clerk of Court, please call the case before us.
Good morning, Your Honors. This is a continuation of the oral arguments on the consolidated petitions in GR number 271059, Representative Erice Lagman, as substituted by Albay 1st District Representative Crisel Lagman et al. Versus the Congress of the Philippines et al. GR number 271347, Aquilino Coco Pimentel III and Pantaleon Bebot Alvarez versus Lucas Bersamin in his capacity as then Executive Secretary et al. GR number E-02472, Filipinos for Peace, Justice and Progress Movement Incorporated or FPJPM, as represented by its President and Chairperson, Mr. Joseph Cadsawan, and Chapter Officer, Ms. Gloria Puzon, versus House of Representatives et al. And GR number E-04036, Edgar Erice and Laila de Lima versus the Senate of the Philippines et al. Thank you, Your Honors.
Appearances, please.
Good morning, Mr. Chief Justice, Senior Associate Justice, members of the Supreme Court, respectfully appearing for Petitioner Lagman in GR 271059, Attorney Lorenzo Tañada.
Good morning, Your Honors. I am Attorney Elmar C. Barreda of the Lagman Law Offices, and I am respectfully re-entering my appearance as counsel for the petitioners in GR number 271059. Thank you very much, Your Honors.
Good morning, Your Honors. Jericho Salenga appearing as counsel for Aquilino Coco Pimentel III and Pantaleon Bebot Alvarez. Thank you, Your Honors.
Magandang umaga, Your Honors. Attorney Joseph Lemuel Bakiran, respectfully appearing as counsel for petitioners FPJ PM, Your Honors.
Good morning, Your Honors. I'm Attorney Renelyn Arellano, appearing as counsel for petitioner FPJPM. Thank you, Your Honors.
The Honorable Chief Justice, Senior Associate Justice, and Associate Justices of the Supreme Court, good morning. I'm Attorney Vopetro Angie Peña. I'm representing petitioners in GR number E-04036, Representatives Edgar Erice and Laila de Lima. Together with me is Attorney Janessa Mariti Codera and Attorney Bianca Isabel Soriano.
Good morning to the Honorable Chief Justice, to the Honorable Senior Associate Justice, and to the Honorable Associate Justices. I am Attorney Bianca Isabel D. Soriano, respectfully appearing for petitioners Erice and de Lima. Good morning, Your Honors.
Respondents, please.
Good morning, Your Honors. Good morning to our distinguished amici. The Office of the Solicitor General respectfully re-enters its appearance on behalf of the respondents in these consolidated petitions. I am Solicitor General Darlene Marie Berberabe. With me today, Your Honors, are Assistant Solicitor General Marisa B. de la Cruz Galandines, ASG George Ortha II, ASG Jennifer F. Fanjalan Legaspi, ASG Samantha P. Kamitan, ASG Orlando P. Polinar. Other lawyers of the OSG are in the gallery to provide assistance whenever necessary. Also with us are DBM Assistant Secretary Romeo Matthew Balangkit, the DBM's representative to the Development Budget Coordination Committee or the DBCC, DepDev Assistant Secretary Roderick Planta, the DepDev representative to the Investment Coordination Committee or the ICC, other representatives from the DBM and from the DepDev as well as from the Bureau of the Treasury are also in the gallery. Thank you.
Madam Solicitor General, may we know if DBM ASEC Secretary Angel Magtalas is around?
Your Honor, she is not around. She is on leave, but Undersecretary Janet Abuel is in the gallery.
Because Justice Kagiwa requested for her presence because she prepared questions specifically addressed to ASEC Angel.
It was manifested to me by ASEC Angel that she has I think she's on leave, on personal leave.
Okay. Sige, we'll take it from there. We'll find out later if USEC
Janet Abuel, Your
can
Honor.
respond to the questions.
Okay, thank you.
so much. For the record, appearing as Amici Curie are Attorney Florencio B. Abad, Professor of Praxis, Ateneo School of Government, Honorable Franklin M. Drilon, former President of the Senate of the Philippines, Honorable Benjamin E. Jokno, for Member Monetary Board, Bangko Sentral ng Pilipinas, and Honorable Jose Maria Clemente Joey S. Salceda, former Representative and Chair, Institute for Risk and Strategic Studies Incorporated. I understand, Congressman Salceda, that would you like to make some manifestation? Please proceed.
Diyos maray na aga po, Senator Campos. Good morning. Actually, mahaba to, pero I decided to compress it. May budget tayo dahil kailangan natin palakihin ang ekonomiya at para po gumanda ang pagkabuhay ng tao. Yung size ng ating budget ay marami pong mga hindi lang limitasyon, kundi meron din nag-enable. Halimbawa, yung mga buwis na nasisingil natin sa mayayaman, halos hindi naman nasisingil. Tapos, kung iisipin mo po, kung ibenta mo po yung Manila Bay, 23 trillion po yan. That's 10 times the GDP of the Philippines. So, hindi ho ganun kahirap ang Pilipinas. Katulad ng Japan, sa Chiba, yung 28% nung Chiba Bay, halos kasing laki na ng budget po ng Japan. Ang sinasabi ko lang po dito, may budget, may pagkukunan, may pagkakagastusan. So, yung pagkakagastusan, may mga limits nasa konstitusyon, nasa kung saan. At saka, kahit nga po itong sinasabi natin, ito pong unprogram appropriation ay hindi po talaga limitasyon dahil sa power of the purse. Kahit saan mo papuntahin yan. Basta po may sasalo po. O hindi po siya magiging, how do I call it? It will be an indefinite or virtually fictitious limitations to the power of the national government or the spending or the executive. So, pag sinabayan mo po yan siguro sa grid o sa swapang, kaya nagkakabulbul po ang ating problema. Kaya ang sinasabi ko talaga dito, at the end of the day, ang pinag-uusapan natin dito, kung gaano kalakas ang ating mga institusyon. Yun lang po. Maraming salamat.
Thank you. The manifestation is duly noted and recorded. Justice Chapardi Mampa will resume his interpellation. Please proceed.
Thank you, Chief. May I request the Honorable Senator Drilon to take the podium and answer these few questions.
Thank you, Your Honor.
Good morning, sir. You mentioned in your opening statement that while the act of classifying funds, either as program or unprogram, is the exercise of the power of the purse. However, you also mentioned that there are costs which are foreseen operational, which must properly be included under the program appropriations. Using this as a standard, will the unprogrammed appropriations then be likened to a fund similar to a contingent fund as it covers costs which are unforeseen?
I'll try to answer that, Your Honor. In my own judgment, the unprogrammed appropriation refers to programs where the funds are not immediately available, but could be available if certain conditions are fulfilled. With that, Mr. Justice, may I have the privilege of trying to understand your question, sir?
Let me cite the case of Belhica versus Executive Secretary, 864 Philippine Reports 461, promulgated on October 8, 2019. In that case, the Supreme Court made mention about contingent funds and program appropriations. I could vividly recall that in that case, it enumerated 11 projects which may be funded by unprogrammed funds, and the court also mentioned about contingent fund, which refers to urgent projects and activities. Precisely, I'm asking you, my next question is, what is the clear-cut distinction between unprogrammed appropriations and contingent funds?
The contingent funds, to my understanding, is designed to respond to contingent events. Example, from my understanding, if a storm suddenly hits the country, if the calamity funds are not enough, the president may look at the contingent funds because the destruction caused by a storm was not predicted, and therefore that is precisely the purpose of a contingent fund, Your Honor.
So there is no clear-cut jurisprudence as to the distinction between program and program appropriations and contingent funds?
None to my knowledge, Your Honor. That is why we're here today, and as I manifested in the last session, I said, this is a case of first impression. I am not aware of any case where the matter of unprogrammed appropriation was precisely brought before this honorable court.
Assuming that the court takes the position that there must indeed be substantial distinctions between programs, between project or program under the program appropriations and program appropriations. As such, the court decides to define what unprogrammed funds are and introduce parameters on the projects identified therein. What do you think, sir? Would this constitute a violation of the doctrine of separation of powers?
My respectful submission, Your Honor, is that if the grant of the power is constitutional, then there is no basis for guardrails being imposed by this court, with all due respect. Because if the power is constitutional and the power is granted to the Congress. Our respectful submission, Your Honor, is that the principle of separation of powers would prevent the intrusion into the powers of Congress, even by this honorable court.
Could this be validly justified under the expanded judicial power of review under Article 8, Section 1, Paragraph 2?
I think it's a question of to what extent this honorable court will exercise such expanded jurisdiction. It's all addressed to the sound discretion of this court.
Sir, you also advance the view that program budget must first be completely covered by any funding before excess could be declared for the purpose of triggering these unprogrammed appropriations, correct?
I'm sorry, Your Honor. Can I have it again? I am a little difficult on hearing. Will the Honor give us?
You also advanced the view in your opening statement that program budget must first be completely covered by any funding before any excess could be declared for the purpose of triggering unprogrammed appropriations.
Yes, Your Honor, because when the budget of expenditure and sources of financing is submitted to Congress by the President, in that submission would be the crucial source of financing for the funds which are programmed. And that is why the unprogrammed portion of the budget was crafted in order to address the issues or address the appropriations, needed appropriations, if the conditions are complied with.
In this regard, you subscribe to the view laid down in that case of Araulio versus Aquino. 737 is Philippine Reports 461, the 457, that it would not be it would be an unsound fiscal management measure to declare an excess, simply to declare the release of unprogrammed funds simply because there was an excess revenue at one source.
Yes, our submission, Your Honor, is that the excess revenue must be reckoned from the whole budget and not the individual sources of revenue. What has happened, Your Honor, is that the budget, the Department of Budget, has taken sources of financing individually rather than the whole government, so that it justified its releases on the unprogrammed appropriation on the excess of collection of individual sources of revenue rather than the whole government.
To recall, the court's ruling in Araulio is anchored on the interpretation of the phrase revenue collections should exceed the original revenue targets.
That's correct, Your Honor. It should exceed the original revenue target. But as I earlier pointed out, it has been the original revenue target was reckoned on an individual revenue source system rather than the whole revenue target of the entire government.
So here before us are petitions which may involve release of unprogrammed funds. And it would appear that it may be permissible if one of the conditions laid down in the 2026 GAA, Chapter 43, Special Fund, are satisfied.
Yes, Your Honor.
This being so, is it a political question to choose whether we apply the individual standard or aggregate standard?
Is it the question? Is it a political decision or question? If we apply the
Individual standard or the aggregate standard?
I think, Your Honor, the Constitution, to my recollection, only says that the unprogrammed revenues or the program activities can only be funded from excess of revenue. The issue in these cases decided by the court, by this honorable court, is whether or not that revenue pertains to the revenue of the government as a whole or individual revenues. My submission, Your Honor, subject to my submission is that these are legal questions that the court can look into, not a political question.
Let's make a comparison. Under GA 2026, Chapter 3, under that special fund, it made mention about this excess revenue collections in any of the identified non-tax revenue from its corresponding revenue collection target as reflected in the BSF. However, in the case of Arroyo versus Executive Secretary, it made an interpretation, as I have just quoted, revenue collections should exceed original revenue measures. Can you point out the glaring distinction between these two?
It is my respectful submission, Your Honor, that the Arroyo decision is an interpretation by the court of a constitutional provision and therefore may not be amended by an act of Congress as it did in the case of, I think it's 2024 General Appropriations Act. Just to reiterate, the decision of this honorable court in the Arroyo decision is an interpretation of the Constitution. And therefore, in that sense, the provision of the General Appropriations Act, which allowed the part of the budget to look at individual sources of fund, to me is improper and unconstitutional.
Is there a constitutional provision which serves as a basis to prohibit the use of a trigger mechanism based on the excess of individual revenues?
My submission, Your Honor, and this is my individual submission, is that these are questions which the court, if I may suggest, carefully examine because the line is not very clear, Your Honor. And that is why all of these issues are being brought to forth because the public, the Congress and the executive branch are not very clear on what the parameters are. And I am conceding good faith to them that it is a question of interpretation and therefore there is need for the guidance of this court.
Sir, do you think we should limit the number or the nature of projects and programs that may be included in the unprogrammed appropriation in order to prevent Congress from indiscriminately transferring projects from program appropriations to unprogrammed appropriations?
As a friend of this court, I would strongly advise against such temptation to impose that kind of a limitation, Your Honor.
To illustrate, the 2024 GAA has 51 purposes, while the 2026 GAA has 3 purposes after the presidential veto. Do you think there is post-enactment discretion with respect to the use of unprogrammed funds between 2024 and 2026 GAAs?
It's difficult to answer that question straightforward, Your Honor, with all due respect, and I must apologize for not being able to respond directly, but as we said, these are questions which the court may want to look at. But at this stage, let me say for the record that this court may want to take a good look at that expanded jurisdiction of the court under the Constitution and determine to what extent this honorable court should exercise such expanded jurisdiction in the many instances that is brought before, or many in the cases that is brought before this court. We are aware that under our present Constitution, it expanded the scope of judicial review. Yes, it has done so, but my submission is that the court should respond to the question among themselves, to what extent would this honorable court exercise such expanded jurisdiction.
Thank you very much, sir.
Well, Your Honor, with your permission, may I read a manifestation for the record in relation to the questions raised by the good justice.
Please proceed.
Thank you, Mr. Chief Justice. Your Honors, throughout these proceedings, it has been my position that unprogrammed appropriations are not inherently unconstitutional and are in fact necessary tools for budgetary policy. For decades now, Congress has included unprogrammed appropriations into our budgetary framework while satisfying the constitutional requirements for an appropriation. Your Honors, the 1987 Constitution expanded the scope of judicial review to include the determination of grave abuse of discretion amounting to lack or excess of jurisdiction on the part of any branch or instrumentality of the government. That's what our Constitution provides. That's why I said earlier, this honorable court is confronted with the question, to what extent should this honorable court exercise such expanded jurisdiction? By expanding judicial review, did the framers intend to authorize this honorable court to review all acts of the government? Or did they instead seek to ensure the grave abuse of discretion could be corrected without eliminating the doctrine of a political question and without disturbing the areas the Constitution principally entrusts to the judgment of our executive and legislative branches, such as the enactment of the national budget? It is my humble submission, Your Honors, that the power of appropriation or the power over the purse was vested by the Constitution on Congress to determine how public funds are to be allocated. Indeed, the courts do not ordinarily inquire into the wisdom of just choosing, for example, funding a hospital over intelligence activities, or funding roads over subsidies, and generally in choosing which public purpose holds more importance and prioritization and method of funding. These are policy judgments we submit, Your Honors, entrusted in the appropriate political branches who, by constitutional design, are in the best position to determine the priorities that they represent. The same principle applies here, Your Honors. I recognize that the concerns raised by the petitioners in this case are not without basis. There are legitimate questions regarding the substantial increases in the unprogrammed appropriation in recent years, the movement of projects from program to unprogrammed appropriations, the breadth of the bicameral conference committee's actions, and the standards governing release of funds. However, in differences regarding policies behind the budgetary process and the existence of concerns regarding its eventual implementation do not necessarily render the underlying constitutional mechanisms invalid. To illustrate, Your Honors, suppose Congress decides to reduce confidential or intelligence funds and instead allocate the same amount to the construction of public hospitals. Few would argue that such an act is unconstitutional. Whether one agrees or disagrees with that policy choice is beside the point. Your Honors, I am not a scholar on the Constitution. I am not a constitutional law expert, far from it. I am a politician, and I am not ashamed of being a politician, Your Honor. But in my 24 years in the legislation, and in the Senate in particular, what I have learned is that adherence to the Constitution is a standard which, by and large, senators would follow. Yes, there are abuses committed, but is the remedy to deprive Congress of the power to formulate policies and appropriate funds in pursuit of that policy? Should this honorable court find that there was indeed grave abuse of discretion, I submit that the remedy is not to deprive Congress of the powers vested in that body by the Constitution. There are remedies available under the constitutional framework. For instance, the President's exercise of his line item veto and administrative charges against those who abuse their powers, while those who have abused their power of the purse must rightfully suffer the consequences of their greed. The problem brought about by unprogrammed appropriations will not be resolved by depriving Congress of its constitutionally mandated power over the purse. That is our humble submission, Your Honor. Just as a final point, Your Honor, as I have previously manifested, I once more urge this court to decide on this very critical question, especially since the 2027 budget will be submitted to Congress 30 days from the SONA, which will be held at the fourth Monday of July. That is our submission, Your Honor, so that all parties, all the public, will be guided by the wisdom of this court in resolving this very difficult issue. Thank you, Mr. Chief Justice. Thank you to the Honorable Justice of this court.
Thank you, Honorable Drilon. Your manifestation is
Sir,
noted. You may continue.
May I ask Secretary Abad to take the podium? A few questions to answer this. Morning, sir.
Good morning, Your Honors.
Yeah, morning. You mentioned in your opening statement that in funding and program appropriations, reality forces three decisions. Namely, one, which appropriations will be funded, two, which will not be funded, and in what amounts. Given these three decisions, would you say that in light of too much discretion involved and program appropriations may partake of the nature of pork barrel
That's one of the consequences if this mechanism stays in the budget, and we do not know what else may happen. I said that point, Your Honors, because if you look at the fiscal condition of the country, the rule is we never really have excess collections of revenues or budget surpluses. In fact, as I earlier mentioned, there have been only 4 instances in our history where we had budget surpluses, and this was the time of President Ramos in 1974, 1975, 1994, 1995, 96, 97. And on the average, it was only about 9 billion pesos surplus. The last time we had excess collections of revenues was still in the 70s. Although there was a claim that in 2024 we had excess revenues, but that's only because we included the cash extractions from PhilHealth and the PDIC, which increased the revenue. But those are not really, strictly speaking, cannot be characterized as tax revenues. If there were instances in the past where excess collections were in fact certified by the executive, it was more because we did not, as Arroyo now dictates us, we did not look at the streams of revenues holistically, and we look at them separately. That's why in many instances, excess of non-tax revenues was used as a trigger to activate the unprogrammed fund, which is now no longer possible. But assuming that that's still possible, in case there is excess collections, usually it's not enough to fund all of the unprogrammed appropriations expenditures authorized by Congress. So what happens is, post-enactment, a decision has to be made as to which of the authorized expenditures should be funded and to what extent, and which should not. And my position, my contention is that this is post-enactment and happening during the period of budget execution, and therefore that power is exercised not by Congress, which has exclusive jurisdiction to do that, but by the executive. That's why I said it creates confusion or a problem, Your Honor.
Sir, in practice, who makes these decisions?
Well, under our Constitution, for example, during the period of budget enactment in the enactment of program appropriations, it is the legislature who must exercise that function, Your Honor.
Yeah. Are there established parameters that they should follow, if any?
Well, one guardrail is that in case of amendments in the budget, it should not exceed the budget ceiling that was provided by the executive. Number 2, care must be given so that the cohesion in the fiscal program is not undermined or disturbed, because the Constitution mandates the President to prepare a national executive program which will serve as a basis for the general appropriations bill. So therefore, care must be given so that the fiscal program prepared by the President is not distorted or undermined, Mr. Chairman. Your Honor.
Secretary Diokno mentioned last week that the unprogrammed appropriations should be limited to foreign-assisted projects. Do you agree that this is the way to move forward to prevent unprogrammed appropriations from becoming a new pork barrel?
In the narrowest sense, that may be possible, Your Honor. assuming there is no mechanism that is in fact provided by the Constitution, because under the Constitution, there is a way of dealing with that through special appropriations. And I think there are quite a number of advantages going the route of special appropriation. Number one is textually, special appropriation is in the Constitution. And program appropriation, to my mind, Your Honors, was never in the contemplation of the framers of the Constitution. I went through the relevant provisions of the Constitution, and I don't see the word or the phrase and program appropriations. I looked at the relevant debates on the Constitution with respect to public finance, and I never see the word and program appropriation. Not even a concept that is closest to it in practice. Even structurally, the Constitution prescribes a complete, coherent finance fiscal program. And I think going through the route of the special appropriations will enable us to achieve that. Institutionally, going through the route of special appropriations will enhance the separation of powers and the independence of branches. While going through the route of unprogrammed operations, it opens us up to the possibility that those functions may be confused. That's why we have seen in 2023, 2024, 2025, the extent of reprogramming of program appropriations that can happen may in fact lead to other possible similar fiscal, I might call fiscal adventurism. In 2023, about 395.5 billion of program appropriations were reprogrammed, were diverted. In 2024, about 564 billion of program appropriations were taken away and reprogrammed to other projects. In 2025, it was about 487 billion pesos. So this is a huge, unprecedented problem created by this mechanism, and we do not know if it had been possible for these diversions to happen. We do not know what else can this mechanism allow to happen, Your Honor. That is why I would rather safely stick to what is provided in the Constitution than risks another of these problems cropping up, which is at present creating a lot of the problems that we are seeing in the country right now.
Thank you very much, sir. That ends my interpellation, Chief. Thank you.
Justice Rudil. Justice Rudil, please proceed with your interpellation.
Thank you, Chief. May I call on our Solicitor General for questions? Before I proceed, I would like to greet you a belated happy birthday. I think it's June 14. Am I right?
Yes, Your Honor. Thank you very much.
Happy birthday.
I spent the day po studying.
So, former Senate President Drilon mentioned about this already earlier. And I want to ask the position of the government on this. Is unprogrammed appropriation as a concept, is it a tool inherently designed to facilitate corruption? Or is it a neutral mechanism that may be utilized for corruption depending on its implementation?
Your Honor, the position of the government is that it is not inherently a tool for corruption. Number one, the unprogrammed appropriations has been present in our GAA since 1989. So from the presidency of President Cory Aquino until the current administration, the UAs, and twice in that period, have been considered by the Supreme Court in regard to its constitutionality or unconstitutionality. In Belgica versus Ochoa and in Araulio versus Aquino, the Supreme Court has given as well what are the parameters, when should an item be a valid item. And Congress has in fact followed, the Senate and the House of Representatives have followed religiously in regard to the Araulio versus Aquino. If I may also insert the position of the government, that our reading of the Araulio versus Aquino is that it was not a constitutional provision that the Supreme Court interpreted, but it was a statutory provision. It was a trigger in the GAA at that time, which led and which also was confirmed to us by the DBM to the revision in the articulation of a statutory trigger. Now, we all know as citizens of this country, many have been angered by what has happened in the 2024 budget. And I think that the political branches have also undertaken steps to course correct or to self-correct itself, because being political branches, they were also reacting to the emotion, to the public anger, and therefore they were also addressing the issues posed by the unprogrammed appropriation. Another reason, Your Honor, that I say that it is not inherently was designed to be a tool for corruption is that in many instances in the past, the administrations, the executive have actually relied on the unprogrammed appropriation, especially during the time of COVID, that President Duterte really tapped the funds on unprogrammed appropriations. Are they vulnerable to abuse? Our position is that any power, I would say, is vulnerable to abuse. And that's why we also tried to point out in the last oral arguments that the PDAF that was considered by the Supreme Court in Belgica versus Ochoa was in fact under programmed appropriations and not unprogrammed. So if there is really a intent, unsoundness or lack or absence of wisdom to our political branches, I think that any mechanism that is provided them or any power may be vulnerable to abuse, Your Honor.
Thank you, Soljen. Can I call on any counsel of the petitioners to answer the same question?
Are you excusing her?
No, not yet. Can stay there. Well,
Good morning,
yes.
Justice.
Do you want me to repeat the question?
Yes, please.
Is UA as a concept a tool inherently designed to facilitate corruption, or is it a neutral mechanism that may be utilized for corruption depending on its implementation? Or in short, do you agree with former Senate President Drilon?
I would agree with former Senate President Drilon. I would answer the question, it depends.
Okay.
Your Honor, it is clear that if the ceiling is fixed, the discretion of Congress as a former congressman is limited to what the President had submitted. And based on the petition of former Congressman Lagman, in the 2024 budget, that ceiling was breached exorbitantly. And now the question will be, why is this so? Is it because that members of Congress saw a possibility that this is a way now to circumvent the guardrails that the Constitution had provided based on jurisprudence under Bellica and Arroyo, to test and push the envelope? That may be.
So, we both agree here that unprogrammed appropriations are not evil per se.
Yes, Your Honor.
Para yung teknolohiya, technology is morally neutral. It is how we use it which determines whether it advances public good or it endorses abuse. Am I right?
Yes, Your Honor.
So this notwithstanding, do you want unprogrammed appropriations to be abolished and declared unconstitutional? Do you want it to be removed from the GAA? Despite the fact that, as a concept, UA is not evil per se.
I will stick, Your Honor, to the position of Petitioner Lagman, which is unprogrammed appropriation is not evil per se.
Thank you, Counsel. You may sit. Now, to the Solgen. Reiterating the question previously of Justice Javier, in terms of the budget preparation and the GAA, why not just include unprogrammed appropriations under programmed appropriations? Why is there a need to distinguish between programmed appropriation and unprogrammed appropriations? And what are the real consequences if unprogrammed appropriations are removed or abolished from the GAA?
Your Honor, the mechanism of the unprogrammed appropriations has been used by the political branches in order to have the flexibility in terms of the fiscal space that the executive has deliberated on and has planned with regard to deficit level. So it works within a fiscal space, Your Honor, meaning if it is able just to commit to an X amount of revenues, then that means that the executive will undertake to earn those revenues in order to fund the programmed appropriations. Other than that, it does not find a power or capability to commit to funding other important programs which we find in the unprogrammed appropriations. So meaning, if all of the unprogrammed appropriations will also be included in the programmed appropriations, then there will be breach, for example, of the deficit level that they think is a sound deficit level. And if I may also mention that even the first world countries have a planned deficit spending. So deficit, having or adopting a deficit spending framework isn't inherently bad. And what the question should be is how sustainable it is. And maybe our representatives also from DBCC could explain that even in the medium-term fiscal framework, there is a target each year until like 2028 where the ideal level of deficit should be achieved. Deficit spending is not bad because if the executive and the Congress will invest in certain projects that have better multiplier, higher multiplier effect, then the economic impact will be more positive. So, Your Honor, it's actually the fiscal space that forces the executive to put in the unprogrammed appropriations. And again, may I reiterate that in unprogrammed appropriations, if there will be no excess or if the triggers are not attained, then there will be no funding for the unprogrammed appropriations, Your Honor.
Soldier. So, Soldier, the Constitution vests in the Congress the power of the purse. And the court recognized this in Pelconza versus Enriquez, as well as in Angnar's party list versus Executive Secretary. But the Constitution requires the President to submit to Congress a BESF, a Budget of Expenditures and Sources of Financing. Does this mean that the Congress is bound by the budget proposal submitted by the President?
Your Honor, with regard to the BESF, then the Congress is bound to observe the ceiling with regard to the BESF as presented. And it is our position that the unprogrammed appropriations being supported by funds that are not in the BESF, then they are not part of that prohibition.
The power of the purse granted by the Constitution is not unlimited, correct?
Correct, Your Honor.
So, this is not a purely political question.
Yes, Your Honor.
To what extent then can this court review the exercise of the power of the purse, particularly on the inclusion of the UAs in the GAAs?
Your Honor, it is the position of the respondents that there are constitutional provisions that we have to check vis-a-vis, or we have to use these constitutional provisions and see if there has been a violation, which is the Article 6, Section 25, Paragraph 1, which is addressed to the legislature that they may not increase the appropriations recommended for the operations of government. Article 7, Section 22 is also a limit. It refers to the BESF, and it is addressed to the executive, to the president, to submit that, and that the form, content, and manner of preparation shall be prescribed by law. Also, the provisions in the GAA must be related specifically to a particular appropriation and limited in its operation to the appropriation to which it relates, which is Article 6, Section 25, Paragraph 2. Also, the legislature is observing all the standards that the court has enumerated in Belgica 2013 and 2019. The test of germaneness, which has been laid down also in Atitio versus Zamora by the Supreme Court. So, Your Honor, it is our position that all these constitutional provisions, we check on whether there was a violation, and it is our position that there was none.
So in short, you are saying that the power of the purse is limited by the textually demonstrable and judicially discoverable standards laid down in the Constitution. Am I right?
Yes, Your Honor.
Can I call the counsel for the petitioner? Anybody from the petitioner's side?
Good morning, Your Honor.
Good morning, counsel. Now, do you agree that the power of review by the court here on the power of the purse should be based on this limitation or within the textually demonstrable and judicially discoverable standards of the Constitution? If
Your
no,
Honor,
why not?
Your Honor, please, it is our humble position, Your Honor, that it is, Your Honor, subject to those guardrails as specified in the 1987 Constitution, Your Honor, because it is precisely the point of the framers of the 1987 Constitution to guard this kind of events, Your Honor, in order for these powers not to be abused, Your Honor, by the Congress, Your Honor.
Is this not a question of policy, considering that these are stated and enumerated in the Constitution?
Your Honor, it is our humble position, Your Honor, that as stated in the petition of the late Congressman Edsa Lagman, Your Honor, it is our position that since the Constitution is clear, specifically Article 6, Your Honor, and Article 7 of the 1987 Constitution, it is our humble position that it must not be interpreted, Your Honor, but it must merely be applied, Your Honor, as enunciated in every decision of this Honorable Court, Your Honor.
So notwithstanding that there is no grave abuse of discretion, as long as there is a violation of the text of the Constitution, you are saying that the court can intrude into such issues.
Your Honor, in order for this it is our humble position, Your Honor, that in order for this Honorable Court to validly decide on the matter, there must be, of course, Your Honor, our humble position, there must be grave abuse of discretion on the part, Your Honor, of the agency subject of the case, Your Honor, as being held in this case, Your Honor.
Thank you, Counsel.
Thank you very much, Your Honor.
So to the OSG, yeah. What standard should this court assess the constitutionality of unprogrammed appropriation in the gas? What should be the guide of this court? Any jurisprudence saying what guide should we follow in assessing this?
Your Honor, the number one would be if there has been a constitutional provision that has been violated in recognition of the expanded judicial power of the Supreme Court. The other question is that if there has been grave abuse of discretion. And Your Honor, we found a case, Defensor Santiago versus Gingona, where the court had two issues on whether there was a violation of the Constitution, and number two, whether there has been grave abuse of discretion. Now, in Defensor Santiago versus Gingona, their number one finding is that there was no violation of the Constitution since the Constitution was silent on the manner of selecting the officers in both chambers. Now, they proceeded to the next question. If there is no constitutional violation, can the court inquire into grave abuse of discretion? And then the court proceeded to define what grave abuse of discretion, and if I may be allowed to read, yes, Your please. Honor, grave abuse of discretion is such capricious or whimsical exercise of judgment as is equivalent to lack of jurisdiction. The abuse of discretion must be patent and gross as to amount to an evasion of positive duty or a virtual refusal to perform a duty enjoined by law, or to act at all in contemplation of law as where the power is exercised in an arbitrary and despotic manner by reason of passion and hostility. And the Supreme Court proceeded to say also that absent any clear-cut guideline, in no way can it be said that illegality or irregularity tainted Respondent Gingona's assumption and exercise of the power of the office of the Senate Minority Leader. And that where no provision of the Constitution has been clearly shown to have been violated, disregarded, or overlooked, grave abuse of discretion cannot be imputed, Your Honor.
Sergeant, what weight do you think is required to establish the unconstitutionality of a law?
Your Honor, it's proof beyond reasonable doubt, which has been cited in the municipality of San Mateo versus Smart Communications, which I understand was penned by your good self. And we also had a survey of several other cases which reiterated the same. So it is proof beyond reasonable doubt. It works on the presumption of constitutionality of the acts or of the laws that have been passed by Congress, and as also revealed in the last oral argument, Your Honor, when the good Justice Amy Javier also asked the petitioners, it is our humble appreciation that the petitioners were unable to give their justification for the allegations that they have included in their petitions, Your Honor.
Thank you. Can I ask any counsel on the petitioner's side? Yeah. Good morning, counsel.
Good morning, Your Honor.
Do you agree, counsel, that there must be a clear and unequivocal breach before a law, in particular in this case, the inclusion of the UA in the GAA, before it may be struck down? Or to prove unconstitutionality, there must be proof beyond reasonable doubt?
Yes, Your Honor. Which is in this case present, Your Honor.
Okay. So you agree with the good Solicitor General in her statement on the weight of evidence to strike down?
On the weight, Your Honor, but again, the position of the petitioners is that we have overcome the burden, Your Honor, for the unconstitutionality.
Thank you, counsel. So, Soljan, it seems to me that the guardrail imposed by the Constitution on program appropriation is the ceiling as contained in the BSF, as you stated a while ago. What then are the guardrails for the unprogrammed appropriations?
Your Honor, the same provisions of the Constitution, because it is our submission that the Constitution sets out the limitations to the power of government. And because the unprogrammed appropriations are not expressly provided in the Constitution, though it is our position that it doesn't necessarily mean that it is not allowed. Okay? Because we based on contemporaneous construction that the political branches have interpreted that it is within their power, in the power of the purse, to include the unprogrammed appropriations without violating what has been provided in the Constitution. So, Your Honor, I would still say that the same constitutional provisions that I have mentioned a while ago, including the guardrails that the Supreme Court has laid down in Atitio versus Zamora, in Belgica, in Araulio, on what constitutes an appropriate provision, the constitutional provision on riders. All of this should still be the guardrails. Number two, Your Honor, and so that's for the legal. The guardrails, as we have seen also when the Congress deliberated on the 2026, when deliberated on the 2026 GAA, the Congress itself also has implemented a lot of reforms, so which shows that there is an opportunity, or they also have a way to course correct For example, in the PhilHealth as well, when the case has been brought to the Supreme Court, the executive has already made a pronouncement that it will restore the 60 billion to PhilHealth. So there are steps, Your Honor, that are being undertaken by the political branches. And the third, Your Honor, if I may add, the guardrails for the unprogrammed appropriations are also contained in these special provisions of when there should be a trigger, what are the triggers, what are the documentary requirements on the certification by the Bureau of Treasury. There are also a lot of processes that are also required upon the DBM. So not because there's already a certification, the DBM also has to have a packet of documents that they will evaluate if it is implementable right away, so that they will not park the sums to a project that is not executable right away, Your Honor.
Now, next question has already been passed upon by former Senate President Drilon earlier. But I go back to your argument that the court should not examine questions of policy. The 1987 Constitution grants this court the expanded judicial power to determine whether there has been grave abuse of discretion by the government. How does this interplay with your argument that the court should limit itself to determining the issues based on the textually demonstrable and judicially discoverable standards in the Constitution?
Your Honor, so we are guided by the Defensor versus Gingona pronouncement by our Supreme Court that if there are no textually demonstrable standards that are provided in the Constitution, then that could also mean that it is not a legal question. So if the Supreme Court would undertake to evaluate policy questions, then that means that the Supreme Court may then have to undertake a task that is open or given to, for example, Congress. So in order to come up with fiscal policy, a fiscal framework, the executive has a very long list of steps or experts to consult. The same way for Congress, in order to come up which program should go to programmed or unprogrammed. So in other words, there is a complete political process as well that can only be undertaken by the political branches. So there is, of course, an inclination when some institutions become weak at some points in our history, there is an inclination to bring the issue to the Supreme Court and look at the Supreme Court as the savior of our country. But it is our humble submission that if there is no textually demonstrable standard, then it is not a legal question, Your Honor.
How then should the court deal with issues where there are no textually demonstrable and judicially discoverable standards in the Constitution?
Your Honor, there is also the coordinacy theory, which actually recognizes that the interpretation of the Constitution is equally distributed in the other branches of government. So of course, the Supreme Court has the final say as to what is the interpretation, but the coordinacy theory could also be a way for the Supreme Court to take jurisdiction of a case, but could differ if it finds that there are issues, that there are no standards, or it does not fall under the grave abuse of discretion to to find jurisdiction but still defer to such questions as belonging to the other political branches, Your Honor.
So this coordinacy theory was discussed by Justice Renato Puno in his concurring opinion in Francisco versus House of Representatives. And he cited this because it is a framework in our constitutional system of separation of powers. Am I right?
Yes, Your Honor. So it's actually a means of reconciling the judiciary's counter majoritarian. So the three branches, the two other branches, the political branches are the majoritarian branches, and the concept of coordinacy was, I think, still in the 19th century. It was first published in the Harvard Law Review and also studied by our academics. One academic, Oscar Tan, says that it allows the judiciary to assume the jurisdiction but could point to the political branches and how the actions can be permissible under the Constitution rather than handling its own interpretation. One academic also said that as the majoritarian branches, the Congress and Executive, their right to be wrong is greater than a judge's right to be correct on a question he or she is not supposed to be competent to rule on. And it is ultimately the electorate that are the final interpreters of the Constitution, since they have the power to amend it. That's a line by one academic, Your Honor.
So you were saying, Solgen, that if the issue involved only errors of judgment or pagkakamali sa pagpapasya ng other branches of the government, and there is no grave abuse of discretion, the petition should be dismissed in this case.
That is our position, Your Honor. At maaari pong dito, yung implementation po ang nakikitang pagkakamali. May mga reaction na rin naman po yung mga chairperson of the appropriation is no longer the chairperson and is currently a fugitive. The House of Representatives also has undertaken a lot of reforms in the 2026 budget. We have witnessed also the live streaming of their deliberations. Both Senate and the House have implemented the reforms in the 2026 budget, Your Honor.
Okay. So what if Congress uses its discretion poorly in preparing the budget? Does this mean that the people are left with no resort?
It is our position, Your Honor, that the Constitution also provides the mechanism. So there's, although it's like post facto, but the mechanisms provided are ombudsman. There is the Commission on Audit. The Commission on Audit, each office, while it is undergoing its activities, should also be checked by the COA. The veto power, the President also can exercise its veto power. The anger of the electorate is also expressed. Civil society is also very alive and engaged at this point, and we feel their anger. They have been relentless as well, and cases have been filed, and with reason. So these are all mechanisms that are provided without relegating to the background also another pillar of the constitutional framework, which is the separation of powers, Your Honor.
You know the case of Cote Scoop versus Secretary of Education?
I came across this.
This was penned by Justice Kagiwa. And Justice Kagiwa said here that policy matters are the exclusive dominion of the political branches. The court will not look into whether a law is wise or unwise based on sound economic theory, and it is the best means to achieve the desired results. So you are saying that these are matters for the judgment of Congress, even if there are serious conflicts of opinions. Therefore, even assuming that Congress uses its discretion results in an unwise or a bad policy, this does not make the issue justiciable.
Yes, Your Honor. I remember coming across that decision, and I put that in the notes to also support the position of the government, Your Honor. We are imagining the temptation really for some branch in the government to address the issues that have been raised to our attention, but we focus on what is the legal issue at hand, and it is on whether the unprogrammed appropriations are unconstitutional or whether there has been grave abuse of discretion, Your Honor.
So in Angara versus the Electoral Commission, the court noted that the Constitution has recognized the judiciary as the rational way, in fact, the only constitutional organ in checking the political branches of the government, especially in times of great disquietude or political excitement. Do you agree with those who assert that given the scale of the alleged corruption, quote unquote, made possible by the UAs, the court's action is exactly required in this case, in these times of disquietude?
It is our position, Your Honor, that there really has to have, we really have to have reforms or changes. But it is our respectful position that because of the reasons I cited a while ago with regard to no constitutional violation, no textually demonstrable standards, then the reforms have to be undertaken using the mechanisms also provided under the Constitution and the political branches themselves. We have had a briefing as well by Congress as to what their reforms have been. So, like, we are told that there is now the budget, the BARC, the Budget Amendment Review Subcommittee, which is a 21-member body representing majority, the minority, and majority and minority political leaders. So, meaning they have also injected some transparency measures, and the BARC recommendations are still to be reviewed by the Appropriations Committee and then elevated to the plenary in order to ensure that there is not a limited number of people who are passing and studying the items in the proposed in the GAB, Your Honor.
Thank you, Soljan, you also mentioned that the Constitution provides for mechanisms to correct unwise policy decisions like the electoral process, the ombudsman, audits by the COA. But these corrective measures appear to be after the fact, when disbursements have already been made, monies have already been expended. Now, are there safeguards before the fact or before disbursements? And are there rules in place to prevent abuse?
Your Honor, I would point to the provisions that are present in many bills, in several bills that are pending in the House and in Senate. It seems to us that when we survey the pending bills, these are in the right direction. So the bills contain like a cap for the total proposed expenditure. So there's a target deficit level. They also are deliberating as to what are the triggers and to already legislate on the triggers so that it doesn't have to be dependent on the administration. There are also some scenarios which they hope to address, like if the DBCC determines that there is a risk of breaching the fiscal objectives in the MTFF, in the medium-term fiscal framework, then that will be prohibited. So it is our submission that the House and the Senate are all deliberating on this in order. These are now like found in the medium-term fiscal framework. So there's a target, but in order to legislate it, the Senate and the House are currently discussing these pending bills, Your Honor.
What about this power of congressional oversight? Is this material in this case?
Yes, Your Honor. So the agencies, after the passing of the GAA, so when the Congress and the Senate can call on agencies with regard to how they have been implementing, are they utilizing the funds that they have been granted in the GAA or the unprogrammed appropriations, and in many instances, corruption or violation of the laws have been raised and highlighted because of congressional oversight, Your Honor.
Soljan, you mentioned about this earlier. Constitutional system also protects itself through built-in self-correction mechanisms designed to adapt to changing societal needs. The court would therefore like to understand whether the UA framework has evolved over time to correct itself. Can you cite some self-correcting mechanisms which Congress and the executive made for purposes of making UA or going out of these questions on the UA?
Yes, Your Honor. So for one, the triggers, Your Honor, have been evolving also. There were periods of time that savings were part of the triggers. Later on, and since 2015, it has, I think, crystallized into the triggers as they are now articulated. Now, a second point is the pending bills on the budget modernization. So there is now in the 20th Congress filed or introduced by Senator Erwin Tulfo, and then the House also has a corresponding Budget Modernization Act filed by Kong Romualdez in October 2025. And then a third correction maybe, a third correction, not maybe, there were significant changes also from the 2024 GAA to the 2026 GAA, like the amounts have been significantly reduced from 731 billion in 2024. In 2026, it has gone down to 150 billion. Number two, of course, because of the guidance of the Supreme Court also, the special provision 1D has been removed. And so there are only 3 triggers for the release of the UAs in 2026. In 2025 and 2026, the President also exercises power to veto. And under the 2026 GAA, there are only 3 purposes for which UAs may be used, unlike in the previous, which was a long list of UAs. So now it's limited to support to FAPS, revised AFP modernization program, and program on risk management. And also the last would be the Bar C. And may I add to the Bar C, the engagement also of the civil society organizations. They have a dedicated a day, or if I remember correctly, 3 days for the civil society to submit questions and to really check on the programs under the departments, Your Honor.
Okay, so the government is saying that the UA framework has not remained static, and that both Congress and the executive appear to have made adjustments over successive budget cycles. From the government's perspective, what significance, if any, should the court attach to this continuing evolution of the UA framework?
Your Honor, that we hope that this honorable court would see that the constitutional framework, in fact, we could say is working, because the political branches who must really be sensitive to the political processes have become sensitive and are doing their best to correct what wrongs have been done. And so also in recognition that if a power is lodged in another branch and without violating the Constitution, that the Supreme Court may find its favorable consideration in allowing them to course correct or to self-correct, Your Honor.
So, Soljan, you're saying that this evolution is relevant in determining the appropriate scope of our judicial intervention?
Yes, Your Honor.
Now, assuming the court identifies areas of concern in the operation of unprogrammed appropriation, must the court necessarily invalidate the mechanism, or should the court just articulate constitutional guardrails while allowing the political branches to continue refining the UA framework?
Your Honor, we believe that the Supreme Court can elucidate on the powers that are lodged in the branches of government, and which constitutional provisions should guide. But there could be also reminders to Congress as to the budget modernization bills, because they're in the right direction. We are all hoping that it should be passed sooner than later, because many of the issues that we are discussing here are contained already and being deliberated in the hearings for these bills, Your Honor.
But that to declare the unprogrammed appropriate unconstitutional totally?
No, Your Honor. We believe that the unprogrammed appropriations are not unconstitutional, and the guardrails for the unprogrammed appropriations, if they are to continue as a mechanism, will then be contained in the budget modernization laws that we hope should be passed soon, Your Honor.
Now, Solgen, have you examined comparative budgetary practices in other countries or jurisdiction on standby spending authority? And are you aware of comparable budgetary mechanisms like the program appropriation in other countries? Can you cite a few if there are?
Your Honor, there is one that is like closest to us, which is in Peru. Your Honor, I have it in my notes, Your Honor.
I think there's another one in Chile.
We
Mexico?
didn't find the. I only have Peru, Your Honor. There are two kinds of budget modifications. Similar to our unprogrammed appropriations, that should there be excess funds, the Finance Ministry would send a copy of resolution indicating the existence of such funds and then given to the Peru's Congress.
So in assessing the constitutionality of a challenged budgetary mechanism, just like the UA, should the court consider the budget practices concerning UA in other jurisdictions? If so, to what extent?
Well, not necessarily, Your Honor, but of course it may be helpful as well to see how other jurisdictions have been addressing in terms of like best practice that could also guide our Congress in passing the budget modernization bill. So I would think that they should be checking and comparing their budget processes with the other jurisdictions. But I say not necessarily, because each country will have its own peculiar circumstances with regard to, for example, I'm not sure as to how fast or how flexible their system could be, which is the one that is being addressed by the mechanism of the UAs in the Philippines, Your Honor. So to a certain extent, to check as to what are global best practices would be very helpful and insightful in order to, and we hope that they will guide our Congress in passing the budget modernization bills, Your Honor.
Thank you, Solgen. That's all.
Thank you very much, Your Honor.
Chief, can I call on Congressman Salceda?
Congressman Salceda.
I think there is some news that you'll be the next Finance Secretary.
Are you appointing you?
So, Congressman
Good morning, everyone.
Hey, good morning.
Sir,
From the government's perspective, what practical purpose does UA serve that would be difficult to achieve through ordinary program appropriations alone?
the word is magnitude.
Can you
Kasi
explain?
yung contingent, hindi yung kakayaan. Usually, you put 10, 15. Tapos, so in other words, as a standby for, let's say, a major disaster like Reming, Pepeng, Ondoy, the ability of the government to respond, you see, there is a golden rule. Kailangan, until you can save the very last life, that is the golden rule of disaster risk reduction. So kung hindi mo masave yun, failure ka, ibig sabihin hindi mo pinagandaan. Kaya yung size, hindi ko kakayanin ng contingent, at saka it takes yung sa, in general, I think the average would be 62 days before you can come up with a supplemental budget. assuming that there are savings that you can squeeze.
So you're saying that it's the size and the time element.
Correct, sir.
Okay. So you mentioned about the COVID-19, Ondoy, Pepeng typhoons in 2009.
Yes,
That were funded by the UA.
Yes,
Yeah.
sir.
So can you cite other instances when the UAs were actually used to fund emergencies and unforeseen expenses aside from those three?
I was thrown to the other side of Congress, which is looking for money. So can I just submit?
But there are lots more.
Bihira, sir.
Bihira.
Bihira na makita ng publiko. Pero alam ko marami.
Okay. So, in your submission to this court, you discuss about RA 992, the Revised Budget Act, which was enacted in 1954.
Yes, sir.
RA 992 allows the creation of a Budget A and a Budget B, according to you. And that was long before the creation and long before the 1987 Constitution. The Philippines already had this Budget A and Budget B. Can you elaborate on Budget A and Budget B?
Yung in-explain po dyan, sir, kasi every time, sir, nag-ano tayo ng bagong lahat ng konstitusyon ng Pilipinas simula 1934. Konstitusyon muna, which is envelope A, then Budget Reform Act, which is your envelope B. So in other words, there is a conscientious, there is a deliberate, it is very deliberate for the body politic na iwala yung constitution at saka yung budget.
So, you are saying that Budget B is essentially a standby spending authority.
Correct, sir.
Would you consider Budget B as the equivalent of what we now call in the budgets as unprogrammed appropriation?
I have to study my... Okay.
Any opinion on this matter?
Layo pa ng... can I come? I don't want to guess, sir. But,
just a guess, an intelligent guess.
But the way it was designed, essentially, they separated the two.
Okay, so, but this is a standby spending authority.
Correct, sir.
And this standby authority structure predates the 1987 Constitution. Am I right?
Since 1934, nung binigyan tayo ng independence, so may constitution doon, tapos may Budget Reform Act. Noong 1937, nung nagkaroon na tayo ng independence, separate the constitution sa... So we had a series of, I think, 5. So iba yung constitution, nauna yung constitution, then sumusunod lang po yung budget reform.
When the framers drafted the 1987 Constitution, would it be fair to say that they did so with the knowledge of this you call as standby spending authority?
I think there would be a sense because there's a recognition that the Philippines is really typhoons. You have typhoons, you have volcanic eruptions, everything. So I think that would be embedded in many of the provisions in the Constitution.
Okay, so
especially on the overarching philosophy was social justice. Yung nasasaktan naman po talaga ay mahirap. So I would say that in recognition of the fact that the Philippines has 19 to 21 typhoons, we have earthquakes, we have everything. So I would say, sir, that it permeates the entire philosophy of the 1987 Constitution.
Thank you, sir. That's all.
Sir, can I just make?
Please.
Sa tingin ko, pwede naman kayo makialam. I don't know whether it is proper for the Supreme Court to define what a BICAM is.
So, just a day ago, in the Inquirer column of former CJ Panganiban, he commented on the present Senate deadlock. He said, and I quote, "While the judiciary has the expanded power and duty to check grave abuse of discretion, historical wisdom warns against prematurely and unnecessarily dragging the non-political robes of the justices into partisan landmines. Until all internal political remedies within the chamber have been fully exhausted, the court should be spared the job of legislative intervention." Can I ask former Senate President Drilon on this? Sir, in the context of appropriations, how do you reconcile the court's constitutional duty to check grave abuse of discretion with the existence of self-corrective mechanisms and legislative measures being done apparently to address these issues?
Your Honor, can I have the question again? I couldn't get didn't get it well.
So, you heard the statement given by Justice Panganiban, or do I repeat it to you?
Yes.
Okay? So, in the context of appropriations now, sir, how do you reconcile the court's constitutional duty to check grave abuse of discretion with the existence of the self-corrective mechanisms and legislative measures being done by Congress to address this issue on unprogrammed appropriation?
Your Honor, with all due respect, I think this court should allow Congress to adopt self-correcting mechanisms, because it is our humble submission that in the unprogrammed appropriations is part of the power to include unprogrammed appropriations is part of the power, an inherent power of the legislature to appropriate funds. And if I may, Your Honor, the existence of unprogrammed appropriation really is something that is difficult to justify in terms of the overall budgetary process. Because from my experience, Your Honor, and if I may share it with the court, when the budget committee would present the budget to the Congress, and we raise questions on the unprogrammed appropriations, the response to us, Mr. Chief Justice, is that we include the unprogrammed appropriation because it is not considered as part of the program deficit. But that is the rationale for the practical rationale for the unprogrammed appropriation. But if you look at it more closely, Your Honor, the President has all the powers under the Constitution insofar as the budget is concerned. From the way I see it, Mr. Chief Justice, the President is very powerful. It can be a one-line budget, and it can be operated by the President. He has veto powers, he line item veto, and the most important, he has the power to withhold releases, even if there is an appropriation. And he can also augment items in the budget. All of this make the president very powerful, and we have only a one-year budgetary law, and the president can do anything. So really, while I am of the sincere belief that unprogrammed appropriation is part of the inherent power of Congress to appropriate, power of appropriation, the fact that the president has vast powers over the budget under our system makes really the unprogrammed appropriations unnecessary. In other words, what you intend to achieve through the mechanism of unprogrammed appropriation can be achieved anyway, even without the items there. I repeat, sir, we have only a 12-month cycle, so that the lack of a program appropriation would not really harm government operations, because, the president can always call for a special session, can always work with the committees of the two Congress to pass the needed legislation in order to allow spending in areas where the president finds it necessary to spend. That's our respectful submission, Your Honor.
Thank you, SP Drilon. That's all, Chief.
Chief, with your permission, can I just ask the Solgen? Since you mentioned a while ago that there are reforms that are being done in the budget process, just for clarity, can you submit to the court at the soonest possible time the resolution of the House or the Senate on these reforms, or better still, if we missed a new law that actually provides for these reforms, or is just this part of your consultations with your client? So since you mentioned to the as responses to Justice Rodil Salameda that there are reforms, please do not forget to submit what these reforms are, preferably in the form of a resolution, if it's in a resolution, or maybe it's just a bill for our information. Thank you.
Yes, Your Honor, we will comply. Thank you.
Considering that it's exactly 12 o'clock at the court's clock, we'll suspend the session for lunch break and then resume at 1:30.
Please rise. Please remain standing while the Chief Justice, the Senior Associate Justice, and the Associate Justices leave the session hall. the Honorable Chief Justice of the Republic of the Philippines, the Senior Associate Justice, and the Associate Justices of the Supreme Court of the Philippines. Hear ye, hear ye, hear ye, all persons for having business with the Honorable Supreme Court of the Philippines shall give their attention, for the court is now in session.
Session resumed.
Please be seated.
Justice Ami, would you want to proceed with your additional interpellation?
Thank you, Mr. Chief Justice. May I call on the Honorable Solicitor General? And she may be joined by the representatives from DBM and NEDA.
Good afternoon, Your
Yes,
Honor.
good afternoon again, Soljan, and happy birthday.
Thank you very much, Your Honor.
I will not ask how young you are.
Thank you, Your Honor.
Thank you. May the representative of the NEDA identify himself, please.
Good afternoon, Your Honor. I'm ASEC Eric Planta of the DepDev.
Eric Planta. And
Yes,
please
Your Honor.
identify again, ASEC.
Yeah, my name, Your Honor, is ASEC Romeo Balangkit from the Department of Budget and Management.
Yes, thank you very much. All right. During the interpellation, last time, Professor Monsod mentioned a relevant research by the current DBM Secretary, Kim Robert C. De Leon, entitled Programming for Unprogrammed, Unbundling the Unprogrammed Appropriations, which was published in 2025 as part of the UP-NC PAG Working Paper series. It was written and published when Secretary De Leon was still assistant professor in UP. You know, I got hold of this paper during the oral argument on PhilHealth. But I just checked it last time. It was not available anymore online. At any rate, it was written and published when Secretary De Leon was still assistant professor in UP. In his paper, he observed that, and I quote, the use of UAs to serve as appropriation cover for ongoing foreign-assisted projects poses a possible breach of contractual obligations with foreign lenders, as well as widening of the government's fiscal deficit. He noted, and I quote, when Congress transfers the loan proceeds component of foreign-assisted projects from program to the UA and proposes a new set of local projects in lieu of such loan proceeds, Congress is actually putting pressure on the executive to borrow more for those local projects that took the place of loan proceeds, since such loan proceeds can only be dispersed for their designated purposes. Meanwhile, the executive is duty-bound to release allotments for the loan proceeds component of the foreign-assisted projects, even when lodged under the UA, because of contractual obligations with the foreign development partners and multi-year contracts entered into with the respective contractors. I would like to restate this using my own words. In other words, when a foreign-assisted project with existing funding is moved from programmed to unprogrammed appropriations, in reality, the transfer covers not only the project, but also the transfer of the fund itself. So that whatever space in the programmed appropriation that seems to have been created by the transfer is merely artificial. In truth, there is no more remaining fund to cover the new project, created to fill the so-called fiscal space in the programmed appropriation. This is the reason the new project will compel the executive to secure a new loan, since being now classified under programmed, it becomes a commitment on the part of the executive. So this is one of the triggers for unprogrammed funds, which is not allowed for programmed funds or appropriation. Do you agree with these statements by the present DBM Secretary, Madam Solicitor General?
Your Honor, yet theoretically that could happen, and our discussion then, when we were asking questions about the transfer of FAPs from program to unprogrammed, what should happen really is that the appropriation, the project and the source of funding should both be transferred from the programmed to unprogrammed, such that if there is a space that is freed up in the programmed appropriation, then there should also be a corresponding source of funding for that, because the source of expenditure for the FAP should have also been transferred to the unprogrammed appropriation. So that is our understanding.
So what is the point of creating the space when there is no remaining fund? And what is the point of moving these projects, which are funded, to the unprogrammed funds when everything follows, not only the project, but also the funding? So what's the point of moving it?
Your Honor, our understanding is that then it will not be part of the fiscal space that is occupied by other projects.
You know, the fiscal space that is created is merely artificial. You know? And the transfer is to pave the way for the creation of an artificial space. Because there's no trigger anymore needed for the funding of the foreign-assisted project, simply because it is already funded. No trigger is needed there. So why move it for the creation of the space, and then the space that has no funding, and the space that the funding of which is actually triggered only by any of the triggers under the unprogrammed fund. So there is confusion.
Your Honor, and that the technical experts can correct me.
Yes.
So in fact, as you are propounding your questions, I'm thinking that the FAPs should actually be lodged in the unprogrammed appropriation.
Is that correct? Or it defies the very definition of unprogrammed, and you cannot divert the funding for the foreign assisted projects because otherwise it is misappropriation.
If I may, Your Honor, while it's true that once you transferred an ongoing foreign assisted projects to the UA, that goes with it the corresponding funding source, which is the loan. And you're correct, Your Honor, there's already an approved loan, so there's no more technically a need for trigger. However, what I have heard, based on conversations also coming from Congress, that the reason that they would also transfer, for example, a DOTR project in the program transferring to the UA is that the utilization rate of that agency may be slow, and in the spirit of urgency, this
may be slow.
Yes.
May be slow.
Ma'am, Your Honor, there's
that is speculative. You know, what I remember is this. It only becomes slow because there's no available funds.
That's also
And
correct.
one
Yes,
of
Your
the
Honor.
reasons pointed to is the delay with DBM with respect to the release of funds. This one should not be moved to unprogrammed when, my gosh, it is so programmed. And, you know, moving it to create the space, it is not visible to the naked eye.
Yeah.
You know, did you notice it?
Your Honor,
No ordinary Filipino will see that. You know, you need not only a 20/20 vision, you need microscopic lens to see it. So it's cloaked into secrecy. Until now, until I've read that paper, I was of the impression that when you move the projects, the foreign assisted projects, you leave behind the fund, which I pointed out during the oral argument in PhilHealth, that is anomalous because we are committed for the purpose for which that loan was borrowed and lent to us. And then I reread. I can't believe that we're moving everything to the unprogrammed funds and leave an artificial space that doesn't carry any funding at all. And so the government is committed to produce that by all costs because it is a commitment. And that's not easily noticeable. You have to really make extra effort to determine that that is what is being done to the movement, to the program, to unprogrammed funds, from program to unprogrammed, insofar as our foreign assisted projects are concerned. All right. So, in 2024, I hope you have this data. How much did the government borrow to fund the local projects that took the place of the FAPs in the program appropriations? How much did we borrow?
Your Honor, I'm just looking at my...
All right, if you don't have them now, please submit them next time. And may I gently remind the parties, including the good Solicitor General, that of your commitment to produce some documents that the court required last time.
Yes, Your Honor.
Yes.
We already requested the DBM for the data, Your Honor.
Ma'am, I have it here, but if you would want to still ask
Yes,
for that.
please.
For 2024, the financing that the Bureau of Treasury contracted for a loan was 1.3 trillion.
Yes, that's quite a sum. All right. So, how do we now say that the unprogrammed appropriations are neutral deficit?
Your Honor, may we clarify, because I think that the good representative from DBCC mentioned a figure that refers to the total borrowings and not the one that
Yes, please clarify that in your submission to the court. So, I go back to my question. After this has been uncovered, how can we now say that unprogrammed appropriations are deficit neutral insofar as the foreign assisted projects are concerned?
Your Honor, because of the nature of the unprogrammed appropriations, and that's why our position is that they are generally not deficit-inducing. They should be deficit neutral.
I'd like to zero in on the foreign assisted projects.
And
so when that is done by the government, how can it be neutral, deficit neutral, when the government is compelled to produce the amount for that project that filled the so-called fiscal space?
Yes, we appreciate, Your Honor, the point that is being made. So for FAPs, I think that what should have been done was to also give an additional source of funding for the one that was moved to the unprogrammed appropriation. And I think also...
So how can it not be deficit generating, enhancing? When the deficit, say for example, is only 200 billion, but because the Congress created a new pet project, a new project under program, which does not have an existing funding, but the government is committed to fund it. So the 200 billion is increased. For example, the deficit is only, say, 50 billion. So with the creation of a new project to be funded by commitment by the government, you add to 50 billion deficit.
Our appreciation, Your Honor, is that there should be another source of financing that should be provided in the programmed appropriation and not a borrowing in order to not result in a deficit.
It's still deficit. You still have to find the funding for that project.
Your Honor, because the sources of financing, for example, have to be adjusted as well. So if the executive is committed, for example, for GOCC, if they identify that the target is 20 billion, then the executive has to adjust and increase their target.
That's the problem there. You sacrifice the original items that have been programmed by the government. All right, just to accommodate this item that seemingly filled a fiscal space when in fact there is no fiscal space to speak of because there was no funding and you need a trigger for the funding to be produced. All right. Anyway, it is NEDA's position that budget and funds flow is the most frequently reported issue in the implementation of the ODA projects. Can you follow? Yes?
Yes,
I'm not
you-
done yet. All right. In particular, the absence of programmed budget allocations in the GAA and the reclassification of funding to UA, which requires revenue availability and DBM clearance delayed releases, actually, disrupted procurement schedules and pushed back implementation timelines. I would like to read the words. This is the Department of Economy, Planning and Development 2024 Official Development Portfolio Review Report that has been published. Okay. It reported that, and I quote, despite the state policy emphasizing the importance of having counterpart funds for implementing ODA-funded projects, among the recurring issues reported is the unavailability, insufficiency, or delayed release of project budget, which causes delay in project implementation. For example, the local governance reform project did not receive any allocation under the fiscal year 2024 GAA and had to rely on a UA request despite having continuing funds. Meanwhile, the capacity building to foster competition project, CB's FCP, received only a minimal GAA allocation, which is insufficient for its planned activities. The PCC requested additional funds under the UA, but was not provided with the required government counterpart funding. Without this, the PCC was unable to utilize loan proceeds as the counterpart is needed to cover taxes and duties. Delays were also linked to late budget requests and local election-related disruptions. Some agencies mitigated the issue by using prior year allotments, requesting special fund releases, coordinating closely with oversight agencies, and adjusting implementation timelines. Notably, DOTR accounted for 55% of all affected projects and is preparing a request for DBM for additional funding under the FY 2025 UAA. So, with this report of our own economic managers, Dev, the former NEDA, what flexibility are we talking about here? You know, the government seems to have equated the presence of unprogrammed appropriations with flexibility, convenience, promptitude, progress, service, and a saving grace against penalties from our foreign creditors. With this report from a government agency itself, the DepDev, are we talking here of flexibility in a good way or flexibility in a bad way? Flexibility that triggers increased budget deficit, increased penalties from our foreign creditors, bad credit standing of our country, and more foreign and domestic debts. And where is the progress we are talking about that is triggered by unprogrammed appropriation? Madam Solicitor General, can you respond?
Your Honor, I think what is being considered now is an interplay of the powers that are exercised by the executive as well as the legislature. Because the executive would have like the technical reports.
Madam Solicitor General, so you're talking of moving forward.
Your Honor, what I'm trying to say is, for example, DepDev, they continue to have maybe technical papers. Even our Congress would
So
also...
we are talking of moving forward. But this court is looking at it backward. Yes,
yes,
you seem to be, you know, looking at the bright things of life.
Your
and
Honor,
that's good. Yes.
Yes.
Moving forward, we shall remedy this, we shall do this, we shall, etc. But the reality is still before us.
Yes, Your Honor. I'm just trying to say that even, for example, the executive would undertake a step, but it continues, its technical experts continue to study and maybe come up with recommendations that are finally, for example, not adopted by the decision makers. So all I'm saying is that the government isn't really, and I think that's a healthy fact that each office, each agency would come up with their own stand, but of course some decisions are left to the decision makers. So even if...
All right, just to focus on the stand of NEDA. This is a report by NEDA. What's wrong with the report of NEDA? My appreciation, Your Honor, is that the NEDA would recommend its study certain courses of action, and then I think to the DBCC. So which part of NEDA's report is untrue?
No, I did not mean to say that they are untrue.
Yes. So far, do you agree with the conclusion of NEDA?
Yes, Your Honor.
Yes. So you agree that there is a flaw, a serious flaw, in moving program to unprogrammed?
Yes, Your Honor.
Yes.
So the NEDA continues to study and maybe make the recommendations to
Yes.
their principal.
Good luck to NEDA. Okay. You're all excused. Thank you.
Thank you, Your Honor.
Justice, thank you very much. I'm done with my interpellation.
Thank you, Justice Ami. Justice Alfredo Benjamin Caguiwa will proceed with his interpellation.
Thank you, Chief. Can I call DBM USEC Janet Abuel?
Good afternoon, Chief Justice and the honorable members of the Supreme Court.
Good afternoon.
Good afternoon po, Justice, Your Honor.
Have you done this before, USEC? Speak to the court?
In the oral arguments in Baguio, Your Honor,
Okay.
for
So
the PhilHealth case,
Medyo sanay ka na.
hindi pa rin po.
Can I ask how long you have been with DBM?
Since 1996, Your Honor, so
Wow, how many
about
presidents
30
are
years.
that? 20 years.
30 years, Your Honor.
30 years, sorry, my math is bad, no? So, in that 30 years, medyo familiar ka na with the process of budget preparation?
I hope so, sir. Yes, I would. I
God
think
help
I
us
am.
all if you don't, no? Alright. Sige, wag kang kabahan because I just want to understand the nooks and crannies of the budget process. So I'm asking you to help me, okay? So coming up with the proposed budget, that entails a very long process, right?
Yes, Your Honor.
And one of the reasons is because government has finite funds that should be spent according to certain priorities, correct?
Correct, Your Honor.
Now, in setting these priorities, it is the DBCC that plays a critical role. Am I correct?
Correct, Your Honor.
And the DBCC is composed of the principals of 5 member agencies. I think it's flashed there. That's the DBM, DOF, Department NEDA, or what's now DepTev, BSP, and Office of the President. And the chair is the DBM secretary. Is that correct?
Your Honor, recently there is an executive order where the DOF is also declared as a chair, a co-chair with the DBM.
Okay.
So there are 2 co-chairs and with NEDA as the vice chair.
The DBCC approves the macroeconomic assumptions and fiscal targets of the medium-term fiscal framework, correct?
Correct, Your Honor.
That's called the MTFF.
Yes, Your Honor.
Is this the same as the medium-term expenditure framework mentioned in the guide, 2017 guide to the 2-tier budget approach?
I would say it is apart, Your Honor, because the MTFF covers the entire fiscal framework where it covers the fiscal side, the sourcing, and the expenditure, whereas the expenditure is on the expenditure alone.
Which is the MTEF.
MTEF, Your Honor.
All right. And when we say macroeconomic assumptions, these refer to the target GDP growth, inflation rate, foreign exchange, correct?
Correct, Your Honor, among others.
Among others, yes. Fiscal targets, on the other hand, refer to the deficit, revenues, and disbursements, correct?
Yes, Your Honor.
Among others.
Among others, Your Honor.
And the data in the MTFF or MTEF forms part of the BESF.
The final figure would be the BSF, Your Honor.
Yes, but the MTF
it's based on the MTF,
yes,
Your Honor.
actually it's Annex A1
Yes, Your Honor.
of all BSFs 2024, 2025, and 2026, correct?
Yes, Your Honor, being the guidepost for all the
Exactly.
yearly.
And this is also reflected in the President's budget message, correct?
Yes, Your Honor.
Okay. In all, the MTFF sets the parameters for the government's expenditure and revenue program.
Yes, Your Honor.
And these macroeconomic assumptions and fiscal targets essentially inform the executive in the formulation of the budget ceiling for the ensuing fiscal year, correct?
Correct, Your Honor.
It informs as well the DBM on what is the most beneficial and efficient use of resources. Tama?
In a way, it gives us the figures, the amounts, but as to the distribution, of course, that
Yes.
would be depend on the priorities for the year.
Of the President, yes. Okay. Okay, at this point, I'm going to go into the details of this process. They say the devil is in the details. Let's try to meet the devil, okay? All
Yes,
right.
Your Honor.
So, budget preparation essentially starts with the budget call, correct?
Yes, Your Honor.
It's addressed to all heads of agencies, departments, commissions, state universities and colleges, and other instrumentalities of the national government, correct?
Yes, Your Honor.
And the budget call is usually issued a year prior to the next fiscal year.
Yes, Your Honor, towards the end of the year prior to the budget.
Oh, even earlier. Okay,
Earlier.
so this budget call addressed to all agencies already sets a budget ceiling for all agencies, correct?
Yes, Your Honor.
Okay. My reference here is National Budget Memorandum number 147, which sets the budget priorities framework for the preparation of the fiscal year. I'm talking about 2024. Agency budget proposals under Tier 2. And it sets the fiscal year 2024 to 2026 Tier 1 ceilings. We have the same reference?
I don't have the document here, Your Honor. But
from your 30 years of vast experience?
I know, I'm not sure about the exact number, but I will not argue against what is on the screen, Your Honor.
Thank you. Okay, let me ask, why is there such a budget ceiling?
The budget ceiling, Your Honor, would be called out from it would be the output based on the macroeconomic assumptions, and it is part of the approval of the DBCC. So that budget ceiling would guide us on the entire fiscal space for the government.
So
for
each
that
agency is
particular year.
informed already of its budget ceiling?
Not specifically, Your Honor, because we have an overall budget ceiling, but we have two-tier levels in budgeting.
Tier 1 and Tier 2?
Yes, sir. Yes, Your Honor. So the first tier would consist of the regular recurring
Ongoing, yes.
expenditures and ongoing programs and projects of the agencies. And
Yes.
they are computed with some inflationary amounts, as well as for the personnel services that would be automatically computed. So they are in a way assured of that, and they are given those levels, informed of those levels. But this one, as to the budget priorities framework, Your Honor, this would cover how the Tier 2 level would be distributed.
Okay.
So this will serve as the guidepost.
I will go there, okay? Okay. So let's go back to the process. Can I ask to flash on the screen so that it's easier for everybody? That's the budget preparation calendar for fiscal year 2024. I'm assuming you're familiar with this.
I'm familiar,
All right.
Your Honor.
So just going through that timeline, the budget call for 2024 was on January 12, 2023, correct?
Yes, Your Honor.
It only says there January, but it's actually January 12. That's based on National Budget Memorandum Circular number 145. Okay. Then a budget forum is held on January 26, 2023. Can you tell us what that is? What is a budget forum?
The budget forum, Your Honor, would invite all the heads as well as the technical personnel of all the agencies. And the DBM would present all of the aspects of and the guideposts for the budget preparation for the budget year. So we will be discussing the macroeconomic assumptions, and then we will be discussing the contents of the National Budget Memorandum, which is that would guide the budget preparation for a particular year. So how do we compute Tier 1, and how do we prioritize and make our proposals for the Tier 2 levels?
Okay. That screen shows only 2 days allotted to it, January 26 and January 27.
Yes, Your Honor.
And the responsible units would be the BTB and the BMB-C. Can you tell us what the BTB is? What does that mean?
The Budget Technical Bureau, Your Honor, is a bureau of the DBM that is in charge of the budget preparation and execution policies of the department.
What is the BMB-C?
The BMB-C, Your Honor, is just, in this case, it covers the government corporations because our Budget and Management Bureau is in charge of the GOCCs.
All right. So BMB stands for
Budget and Management Bureau.
Okay. All right. So that's done in January. And then come February 23, nagkakaroon na naman ng consultations with the RDCs, CSOs, etc. The RDC here refers to the Regional Development Council, right?
Yes, Your Honor.
And each RDC is composed of, I'm reading to you from Republic Act 12-145. It is composed of provincial governors, city mayors, mayors of municipalities designated as provincial capital, provincial chapter presidents of the League of Municipalities, and the regional heads of DEP, DEV, BSP, CHED, DAR, DA, DBM, DepEd, DOE, DNR, so forth and so on. Other agencies that the RDCs deem critical to the respective regions and private sector representatives who comprise 1/4 of the regular membership of the RDC. My question is, ano pinag-uusapan dyan?
It's practically the same structure as we do at the central office level. Initially po, our regional directors, the DBM regional directors would present also the macroeconomic assumptions, the budget priorities framework, and ultimately the regional offices of each department would present before the Regional Development Council on the levels of their
Yes.
budget proposals
Okay.
within the region.
But is it a forum where the governor, the city mayor, the mayor, that's a forum for them to come in and say, uy, gusto ko ng bridge dito. Uy, gusto ko ng eskwelahan dito. Uy, gusto ko ng ospital dito. This is where all of those wishes are expressed, correct?
Supposedly, Your Honor, the assumption is that all of the requirements of these LGUs were already presented to the respective regional offices of the different agencies prior to the budget forum.
Okay. But in the consultations themselves, ano nangyayari?
Right, Your Honor. In the consultations themselves, they will see what the proposed items are at the regional level. So they will see if their requests were included by that regional office or not. And you are correct, Your Honor, when you say that this is also where they will present that that if a project is included or not. So most of the time, if a project is not part of the budget proposal presented, then the governor or the mayor would ask the reason for exclusion.
And present if they want.
Yes, Your Honor.
Okay. Is this where the PAPs are eventually identified and prioritized?
At the level of the region, Your Honor, we say yes. And the next would be they should endorse it to the
Yes.
central agency office.
Okay. So that by February, the period February 1 to April 28, again, can I ask that the schedule be flashed on the screen? Yes. So February 1 to April 28, ang nakalagay dyan, encoding and submission of past year's actual obligations and fiscal year revenue program. Can you tell us what that is all about?
This is just a part of the reporting of the data that would be needed in the BSF, Your Honor. So this would be for the past year's actual obligation. So if you would see the BSF and the NEP, we have for example, we are in the 2026 budget year. You have actual for 2024, 24. Then you have 2025 current, and if your budget year is 2026, that's for the budget year. So that is just part of the data that would be needed, because that would form part of the final picture of the booklet.
Yes. But the period here, according to that calendar, is from February 1 to April 28. That's about 3 months. Can you tell us why it takes that long?
I cannot venture into a very sure answer, Your Honor, but I believe it would take much time, since that would be required from all of the agencies as well as the GOCCs and the other offices. Okay. But that does not mean, Your Honor, that some of the items some of the activities there are not being done as well. For example, on April 17, they also have some other submissions.
Okay, that's why. So let's go to the next entry there. Nakalagay dito, April 14, 2023, issuance of NBM for Budget Priorities Framework by the FPRB. Ano ba yung FPRB?
Fiscal Planning and Reforms Bureau, Your Honor. It's
Silang
a part
gumagawa
of the
ng mga
DBM.
National Budget Memorandum.
Our national budget memorandum is being prepared by the BTB, but the FPRB contributes insofar as the macroeconomic side is
Okay.
concerned.
Okay. So, following again the schedule, pagkatapos niyan, for the period April to May 15, the agency submit budget preparation forms, which include details of Tier 1, forward estimates, and Tier 2 new spending. Tama?
Yes, Your Honor.
And during that same period, there are technical budget hearings for Tier 2 proposals,
Yes, Your Honor.
including program convergence budgeting.
Yes, Your Honor.
Ano naman ang ibig sabihin yan?
The program convergence budgeting, Your Honor, is a means where one particular lead agency is identified to lead convergence of different or you can say separate programs that actually should converge, like tourism, but they are found in different departments.
So tourism and then
Roads, you have that.
airports,
Airports, yes, Your
ganon
Honor.
klase.
Yes, Your Honor. So there's one agency on top of it for
Okay.
the PCB.
So, itong sa technical budget hearings, do I understand it correctly that the participants are the budget management bureaus, the regional offices, and together with all other agencies? Ganun ba yan?
The technical budget hearings would cover each agency, Your Honor. It would consist of the DBM as lead. Sometimes we have the DepDev if necessary, and some other resource persons from oversight agencies. And we will be hearing the budget proposals for Tier 2 of a
Ayan.
particular
I wanted
agency,
to
Your
ask,
Honor.
ano ba talaga nangyayari dito sa mga hearings na to? What actually happens?
The intention, Your Honor, is for us to be able to appreciate as part of the evaluation, the budget proposals of the agencies. We will be looking into the absorptive capacity of the agency, meaning how much did we release, how much allotment did we release from you, how much did you obligate, and eventually from those that you have contracted out and obligated, how much did you pay. And ultimately, it should explain to us the particular stage of a particular project, in that if we notice some slippage, or in case because we do agency performance reviews and we ask them, why
Okay.
do you have negative slippage insofar as the financial performance and physical performance are concerned? Because financial is just computing how much they disburse out of the obligation. But insofar as the physical is concerned, at which % of work progress are you already
So medyo
into?
mabusisi ito.
Mabusisi po, Your Honor.
At saka malalim.
Malalim po, Your Honor.
And how long does the schedule give you? April 17
Less than
to May
almost
15?
a month.
Almost a month, no?
Yes, Your Honor.
Okay. And after all the technical budget hearings, nagkakaroon ng executive review board hearings. Hearings ulit.
Yes, Your Honor.
And involved are the Budget Technical Bureau or the BTB, Budget and Management Bureaus or the BMB, the RTF. What's the RTF?
Regional Task Force, Your Honor. They are in charge. They are from the regional offices in charge of the state universities and colleges, the budgets of the SUCs.
Okay. And then the LGRCB or the Local Government and Regional Coordination Bureau, the OPCCB. Grabe ang gobyerno, panay acronyms. Pati sa Supreme Court, panay acronyms. Organization, Position, Classification, and Compensation Bureau, the LS or the Legal Service, the FPRB, Fiscal Planning and Reforms Bureau, SPIB, Systems and Productivity Improvement Bureau, and the NCR. May I know what NCR means?
National Capital Region, Mr.
That's what it means?
As Your Honor. And they are in charge of the MMDA.
Okay. And then after all that, from June 20 to 21, Yan yung presentation to the President and the Cabinet, correct?
Yes, Your Honor.
Okay. And this is done by DBM FPRB?
It is done by the DBM Secretary, Your Honor. The preparation is led by the
FPRB. All right. But the presentation is done together with the DBCC.
Together with the DPCC and some technical
Yes.
people.
And I assume, therefore, that since the DBCC is there, their participation is focused on the macroeconomic and fiscal targets, correct?
Yes, Your Honor, but I believe that some of the items that need to be discussed insofar as prioritization is concerned would be also taken up in with the economic managers or the DPCC, but it's not a particular written rule for that. But
Yes, in other words, magmi-meeting kayo, nakaharap niyo yung presidente, pipresenta ninyo yung plano, harap ng kabinete, and then pag-uusapan.
yes, Your Honor.
All right. And is it at this time that the budget of the president is approved?
In principle, Your Honor, we could say yes, but subject to some
Yes.
adjustments,
okay. The cabinet
depending on the
meetings-
instructions.
The cabinet meetings I've attended is pagkatapos ng presentation, i-adjourn at sabihin, okay, yan na yan. Subject to this, subject to that, subject to this.
But there are times, Your Honor, that there are sometimes what we call hearits. Hearit, like they will ask for more consideration and
We're talking about the different agencies.
from the agencies, Your Honor.
who are
Although we
present,
have
who are present or represented by their cabinet secretaries.
Yes, Your Honor. So when we present to the President, we always say at the end that it's a zero-sum game. Meaning, if you want more for you, tell us where you want to
Take it
us to
out.
get it
Yes.
from. But sometimes that does not happen, that it's fixed at that level.
Have you attended these cabinet meetings?
Yes, Your Honor.
How long does it take?
It would depend, Your Honor, sometimes, well, at least an hour.
An hour lang?
An hour to two. So at least, sir.
Okay, okay. So after na-approve na yan, the schedule says that from June 23 to July 1, that's about 1 week, fina-finalize nyo na yung NEP, yung BSF, staffing summary, and budget message. That's the period of time you do all those 4 things, correct?
Yes, Your Honor.
All right. And then finally, sinasubmit nyo the entire budget documents to the President by July 20, 2023.
That's indicative, Your Honor.
Yes,
because-
of course.
Yes, so around that time, Your Honor. Before the SONA.
Yes. And then the President submits his budget to Congress on July 24, 2023. I'm talking about 2024.
It would depend on the final decision, Your Honor. Sometimes on the day, sometimes a week after, sometimes a day after, or sometimes before the deadline.
Basta before SONA.
Before the third, Your Honor, within 30 days
Within 30
after
days
the
from
SONA.
SONA. Okay. Okay. Can I just ask, this schedule of activities, normally that's followed on every year, no? More or less?
The months, Your Honor,
The months, in
we
the
could
periods
say
of time.
yes.
Yes, no?
We could say yes, Your
Okay.
Honor, unless, but I would say yes, Your Honor, as to the months because that is, those are our targets. But
Yes.
for example, the submission to the President would also depend on when the President
I guess my
would
question
say.
is, on a regular basis, on a yearly basis, this is more or less the schedule of activities and the timelines that are followed by the DBM.
Yes, Your Honor.
Okay. Now, going to the screen, it makes mention of Tier 1 forward estimates and Tier 2 new spending. I think that's slide number 7. There. I get these from NBM number 145, January 12, 2023. And for the record, let me read that Tier 1 is estimated cash requirements for ongoing PAPs and commitments at the same scope and quality. This is based on the current year's GAA. Tier 2, proposals for scaling up expansion of existing PAPs in terms of changes in scope, beneficiaries, timeframe, or outputs, and proposals for new priority PAPs in the Philippine Development Plan approved by the Economy and Development Council and identified in the budget priorities framework. So tama ba ako in my understanding, Yusek, that Tier 1 basically sets the baseline for the required budget for the succeeding fiscal year?
Yes, Your Honor.
And that baseline is important precisely to determine this much bandied about phrase, fiscal space.
Yes, Your Honor.
And fiscal space is the available funding for the government's priority programs, correct?
Yes, Your Honor.
And of course, the fiscal space is finite. It's a finite figure. Tama?
Yes, Your Honor.
Can you tell us more or less when this finite figure is determined? Can we go back to the schedule of activities? In this schedule of activities, more or less, in what months do you determine the fiscal space? Is that the one in April?
As early as the issuance of the budget call, Your Honor is concerned. That already guides us.
Yes, but
and
the final finite amount equivalent to the fiscal space, kailan na determine yan?
The remaining fiscal space, Your Honor, after the Tier 1
Tier
is
1.
after the submission of the Tier 1 amounts. So that would be before the TBH, the technical budget hearing.
Anong month yan?
Sometime April 15 to May 17 in the next slide po.
So thereabouts, April.
Yes, Your Honor.
Okay. My understanding of Tier 2 is that it's the fiscal space.
That's the remaining fiscal space. But Your Honor, yes, you are, because we usually call it, that's our fiscal space. And
Yes.
that's after the Tier 1.
Correct. So after
Yes,
you
Your
determine
Honor.
Tier 1, yung naiiwan pa kasi finite nga yung resources natin, yan ang tinatawag nating fiscal space,
Yes, Your Honor.
which is Tier 2.
Yes, Your
All
Honor.
right. And again, can you bring up na lang for everybody's consumption? I get this from the glossary of terms of the BESF 2024. Fiscal space is defined as the available funding that the government could use for its priority programs. Is computed as the difference of projected obligation ceilings and forward estimates of the cost of ongoing programs. So tama yan.
Yes, Your Honor.
Okay. Can I now refer you to NBM number 147 entitled Budget Priorities Framework for the preparation of the fiscal year 2024 agency budget proposals under Tier 2. Again, I'm assuming you're familiar with this.
Yes, Your Honor.
Okay. It says here, Tier 2 proposals shall be evaluated taking into consideration certain things. So, I'd like to focus on 3.2.3.2, implementation readiness, 3.2.3.3, absorptive capacity, 3.2.3.4, consistency with the priorities in the BPF. These are required by you, right? In the evaluation of Tier 2 proposals.
Yes, Your Honor.
Meaning that every Tier 2 proposal should be implementation ready.
Yes, Your Honor.
And by implementation ready, you mean that the proposal is, I think it's there, supported by feasibility studies, detailed engineering designs, annual procurement plans, relocation action plans, right-of-way acquisitions, agency operational plans, agency sector roadmaps, network plans, interagency clearances and permits, and proofs of coordination with LGU implementers. Ito yung mga dokumentong hinahanap nyo to support that a project is implementation ready. Tama?
Yes, Your Honor.
Okay. And then the proposal must also indicate the absorptive capacity and that it is aligned with the priorities in the budget priorities framework. Tama?
Yes, Your Honor.
Okay. And then sa item 3.2.3.4, the agencies should rank their budget proposals by an order of priority, correct?
Yes, Your Honor.
Okay. So going back to the calendar of activities, the proposed budget for Tier 1 and Tier 2 is translated into the National Expenditure Program, otherwise known as the NEP, correct?
Yes, Your Honor.
With amounts allocated for each PAP, correct?
Yes, Your Honor.
By PAP, I mean Program, Activity, and Project.
Yes, Your Honor.
Just a side note, and to be clear, yung BSF, what it provides are aggregates or lump sum appropriations, correct?
It does not pertain to appropriations everything does not pertain to appropriations only.
I guess
Your
my question
Honor.
is, it does not identify specific PAPs and their corresponding appropriations.
The specificity, not much,
Yes.
but for a program, Your Honor, they also have under the expenditure program portion.
But the specificity that we see in the NEP happens only in the NEP.
Yes, Your Honor.
Okay. So when we speak of the President's budget, we're not talking only of the BSF, we're also talking of the NEP, correct? Because that is where the identification of the specific PAPs are made.
Insofar as the President's budget is concerned,
Yes.
it's the position of the DBM that it is the BSF which is submitted by the President.
So bakit pa kayo humihingi ng NEP?
Because it covers the expenditure program of the government that is needed to be authorized by Congress. Because the BSF, Your Honor, would also contain the data or the amounts for the automatic appropriations, which will not factor into the GAA as well as in the NEP.
Can the President approve only the BSF and have a budget based only on that?
Based on, so under the Constitution, Your Honor, what is required is the BSF. But in practice, as identified, if I'm not mistaken, under E-02472, what is being submitted is the the four documents that you have mentioned earlier, the NEP, the staffing summary, the BSF, as well as the President's budget message.
So as far as E-02472 is concerned, it's all four, right?
Yes, Your Honor.
Okay. Before I go on, just for my information, what determines whether a PAP is listed in the program appropriations or in the unprogrammed for purposes of preparing the NEP?
It will be presented, Your Honor, under the other items except the UA. So anything that is in the NEP, anything that is not in the UA, they are considered program.
Sorry, anything that is not in the NEP, in the program
In the
becomes unprogrammed.
anything that is not under the unprogrammed appropriations, they are programs because they are programmed appropriations. They occupy almost all of the pages of the NEP.
Now, what I'm saying is this. So meron ka ng Tier 1.
Yes, Your Honor.
So you have an X amount. That's for ongoing projects and even for some expansions. I'm sorry, just ongoing, no? Including inflation. Yung Tier 2, yan ang pinag-aawayan ng lahat ng ahensya.
Yes, Your
Di ba? Kasi we have a limited source of funds eh. So, sa Tier 2 na yan, what comes into play for you to say na itong PAP ay dapat na sa Tier 2 at hindi sa unprogrammed?
The one that we have shown, the parameters, Your Honor, fiscal space, implementation readiness,
Yon.
prioritization using the budget priorities framework, and the absorptive capacity.
Okay. So is it safe to say that para mahulog ka sa Tier 2, dapat you're compliant with all those things that I read earlier. Implementation ready, blah, blah, blah.
Yes, Your Honor, but
there are some
we
parts,
cannot accommodate everything because of the fiscal
Correct.
space, Your Honor.
So therefore, there are such PAPs that are implementation ready, etc., but you have no choice but to put them in the unprogrammed.
Yes, Your Honor. Like that's why we are asking the agencies to rank also.
Yes,
so that
exactly.
when we do prioritization, we prioritize the other programs ranking higher in the program
Okay.
appropriations.
So, in other words, when the budget call was made at the latest January, no, up to the time of the submission of the budget documents to Congress, ilang buwan yan yung entire budget preparation phase?
Practically, we start
7 months.
January up to July. Your
July. So
Honor.
that's about 7 months. Okay. So it is fair to say that what you have just described, I can conclude that the budget submitted to Congress underwent careful study and review.
Yes, Your Honor.
Meaning, again, to flesh it out, all the individual PAPs listed in the NEP were extensively and thoroughly studied by the agencies for at least 7 months. Tama ba yun?
Yes, Your Honor.
Okay. And the careful study of all these PAPs, that was necessary because we are implementing the government's priority programs, correct?
Yes, Your Honor.
So, if you significantly alter the PAPs proposed by the President in the NEP, you do not only introduce PAPs that were not comprehensively studied by the government agencies, you also change the national plans and priorities of the government. Would that be a fair statement to make?
At my level, Your Honor, I would say that that would depend on that level. For example, in case of Congress, I wouldn't want to conclude that those are not implementation.
I didn't mention Congress changing them. But
Yes,
if they were changed, wouldn't that be changing the priorities of government?
theoretically speaking, Your Honor, you would say that the PAPs are changed, but as to the priorities, specific PAPs, yes, they may be changed, but some that would be substituted might be consistent with the priorities as well. They may not be higher ranking, but that they may be within the priorities or consistent with the PDP
But they
and
may also
BFP.
not be.
They may also not be. Your
And for those PAPs that are not, then they're essentially changing the game plan, di ba?
that would not be consistent with
Yes.
the
Okay.
priorities.
And that is why, since you have all the information and assets in the agencies, that is why the budget preparation phase is done by the executive, di ba?
Yes, Your Honor.
Okay. Anong legal basis ba yan? Can I just slide 11? This is Section 3 Declaration of Policy of the Admin Code of 1987, Book 6, Chapter 2. I find that to be the legal basis of doing the budget in that particular way. I suppose you can confirm that you rely on this, correct?
As to the process, the guiding post, yes, Your Honor.
The North Star.
Yes, Your Honor.
Okay. And when we say that the budget should reflect the policies of government, the prioritized policies are found in the Philippine Development Plan, correct?
Yes, Your Honor.
Okay. So, when agencies propose PAPs during budget preparation, these PAPs should already be aligned with the PDP, correct?
Yes, Your Honor.
Okay. Can I just, for everybody's consumption again, EO number 14, January 27, 2023. That is the mandate, right?
Yes, Your Honor.
Okay. And this is why the budget preparation phase dovetails with the budget execution, because who better to prepare the budget than the branch of government that will implement it, correct?
Yes, Your Honor.
And so, again, when PAPs are inserted or appropriations are increased after the budget has been finalized and submitted to Congress, there is no guarantee that the executive can implement these inserted PAPs or increased appropriations, correct?
Yes, Your Honor. That's why most of the time there is a provision in the President's veto message which requires that increases or adjustments made by Congress insofar as to that effect, insofar as PAPs are concerned, shall be subject to some requirements and ultimately the approval by the President.
Kasi nga, these PAPs may not have gone through the rigorous process that normally attends the PAPs that found themselves in the NEP.
Yes,
correct?
Your Honor. So one of the most important things there is if it is consistent with the priorities of the government.
In other words, posibleng tanggalin ang isang PAP na pinropose ng executive at paltan ng ibang PAP na pinropose ng Congress, at hindi rin matutuloy yon kasi hindi naman alam ng ahensya how to do that. Am I more or less correct on that?
There may be instances that would be applicable, Your Honor, but there are also instances where the
Nakaya.
agencies themselves are requesting for the release and giving justifications.
Oh nga, that's the funny part eh. You have the agencies who are under the President asking for more from Congress instead of the executive, no? I mean, it is what it is. Ganun ba yan?
Yes, Your Honor, we would suppose that it's out also of the necessity, being the departments, and it's also their priorities at their level. It just so happened that it does not rank among the highest, and they are chopped off because of the fiscal space that we have.
But yun na nga ang tanong ko eh. It's a zero-sum game eh. So when these different agencies go to Congress and lobby for additional, may matatanggalan eh, di ba? And kung may matatanggalan, then in that situation, you have the agencies of the executive essentially subverting the plan of the President because of this lobbying. Di ba? Mali
Yes,
ba
Your
ako?
Honor, that happens.
I
Your
know,
Honor.
kaya nga, let's call it is what it is, di ba?
Yes, Your Honor.
But
Yes, Your Honor.
does it make sense to you?
Yes, Your Honor.
It does. It makes sense to you.
It
Given
makes
the
sense
limited
that
fiscal
it
space.
happens.
In the sense
makes-
that it happens.
It makes sense that it happens, Your Honor, and we also know the reason because they feel that their PAPs are priorities over the others, and if all of them feel that way, then we have a problem at the executive because we really don't know which one to give. That's why we ask them to rank. But sometimes they believe that some of their PAPs need to be pushed further. They go to Congress.
Okay. I'll give you another situation, all right? This is not increasing a PAP. This is creating an entirely new PAP, meaning an entirely new program, activity, or project. That will have to replace another item, correct? In other words, pag nagpasok ka ng bagong PAP, it takes up the fiscal space allotted for the PAP originally proposed by DBM, correct?
That would be the necessary consequence
Correct.
working within the
Kasi zero-sum game ka eh. Mm.
Yes, Your Honor.
And again, for that new PAP, there is no guarantee na ma-execute ng executive yung new PAP na yan. Totally different, from what it replaces. There is no guarantee.
I could not conclude with absolute 100%
My question is,
affirmation,
wala kang
Your
guarantee.
Honor.
Hindi tayo makakasiguro.
Because some agencies would request and might be
Okay.
able to implement if that is their initiative, Your Honor.
Okay. Next question for you, Yusek. When certain PAPs are moved from programmed to unprogrammed, this also results in a disregard of the priorities of the executive. Can we agree on that?
What I can confirm, Your Honor, is that whatever is in the President's budget is the priority of the President.
Meaning, everything is priority.
In the NEP, Your Honor.
Yes, but
Under the UA,
pero inurong mo nga eh.
from the program to the unprogram.
In other words, sabi ni Presidente, itong PAP na to, gusto kong unahin to kasi this is my legacy. Tapos nilipat sa unprogram na nag-iintay ng pondo. Yung appropriation cover naman nito ay kukunin ng ibang PAP. That has nothing to do with my priorities. So hindi ba I'm correct in concluding that in such a situation, the priorities of the President or the main architect of this country are subverted?
Insofar as the NEP is concerned, Mr. Chair, since that is the President's budget, whatever's in the UA would be, as described by the Honorable Solgen, is those that are implementation ready, also priorities, but not as urgent as those in the program.
No, but I'm talking,
it would be different
yes.
from
I'm talking about
NEP
when you
to
yes, to GAB, to GAB.
So NEP to GAB, Your Honor, if I may be forgiven not to comment on that because I feel that that would be an interference to the legislative wisdom.
Oh my gulay.
That the Solgen is trying very hard to defend.
Okay. Sige, Yusek. Thank you. Salamat.
Thank you, Your Honor.
At this point, can I call Secretary Butch Abad? Just a few questions.
Good afternoon, Your Honor.
Hello, Secretary Butch. Amici Sulita Monsod stated that when insertions are allowed, the Philippine Development Plan is essentially diluted, and the GAA is no longer the budget that embodies the President's priority programs and development plans. Can I have your take on that? Do you agree with that?
So, if it's done in a certain magnitude, then it will. But it happens that, you know, some of the changes are marginal, then they're not the problem. But if it's on a scale that's huge, then it will, Your Honor.
In your experience during the time that you were DBM Secretary, what kind of insertions happen?
Well, sometimes, you know, because certain events happen like a calamity, a typhoon, or an earthquake, or the province undertakes a program for its development and they shift priorities, then you can make adjustments. But this do not necessarily undermine the priorities set by the President in the National Expenditure Program.
So, I'm sorry, the word you used was marginal?
Yes, it really doesn't undermine the development directions set by the President. In fact, in some instances, it may even enhance.
All right, I'm assuming you've studied the 2024, 2025, and 2026 budgets?
Yes.
And how do you describe those changes? Are they marginal?
They are unprecedentedly huge, starting in GEA 2023, Your Honor.
And the scale was how? How would you describe the scale of the changes?
If you were talking about Tier 1 and Tier 2. Yeah, Tier 1 is the expenditures that the government is committed.
Yes.
And Tier 1. Tier 2 is where the President makes an imprint on what his priorities are.
Yes.
Either through new programs or the expansion of existing programs. Insofar as Tier 2 or the fiscal space, if you try to compute the proportion of the amount of funds that were taken from the program appropriations in 2023 up to 2025, they would be up to the magnitude of about 25 to 30%. It's huge, Your Honor.
What is huge? 25 to 30% is huge?
Yes.
Is there actually a figure to this?
Well, if you look at the Bicameral Conference Committee report, you will see an indication there.
Actually, I'm going there later, no? Yeah.
Like, for example, in 2023, there is a column that says decrease in the budget, and in 2023, the amount says 395.5 billion. And then in another column, it says increase in the budget, and 395.5 appears, which means 395.5 billion of POPs were taken away from the program appropriation of the 2023 GAA and replaced with other POPs. Or maybe they increase existing POPs, like infrastructure. And that's why you can see it's huge, because it involves this amount of money.
As a former budget secretary, Sec Butch, during your time, what did you do to ensure that the budget was the engine for the country's development?
Well, we did not have diversions of this magnitude, but I would constantly monitor the budget process in the House or in the Senate. And if I hear from our people, or even from other agencies, that certain amounts like 5 billion was taken from their budget, for me that is a signal that we should look at this, because if others learn about this and we tolerate this, then it may lead to more diversions of the budget submitted by the executive.
So can I ask, as budget secretary, hearing all of those things, what did you do?
Well, I would first of all verify whether it is true, and if it is true, I go and speak to the committee, chairman of the Committee on Appropriation.
And they listen to you naman?
Most of the time they listen, but usually in conference with the proponent of the change.
Okay.
But if they don't listen, then I go up to the speaker. And if still I cannot get anywhere, at least I inform the president that there is such a change that is taking place.
Using your words of the huge scale of new PAPs replacing the PAPs of the president, and all of them taking up the finite funds. In other words, the conclusion is that the money was not, to say the least, efficiently and effectively used. Is that a correct conclusion to draw from this?
Well, if you look at the items to which the funds taken from the program were diverted to, I can say that in a substantial way, they're not.
All right. Thank you, Secretary Butch. Thank you. At this point, can I call on former Senate President Franklin Drilon, sir?
Thank you, Mr. Justice, but before that, just to augment our knowledge of the budget process. When the President's budget is prepared, there is such a thing as personnel, miscellaneous personnel benefit fund. What is this fund, Your Honor? This is, I would call it bluntly, a slush fund, but a fund which is used by the President as an instrument to cover whatever adverse effects of the exercise of Congress or budgetary power. The miscellaneous benefit personnel fund it is arrived at, and I don't know whatever is the base was, but there is just a fund there which can be utilized. And that is why all the concerns that may be raised are, as long as the realignments are not of the magnitude that we saw in the last 3 years. There are many items in the budget which already considers the fact that our Congress would have their own policy advocacies, which would require funding. And as a matter of interplay between the executive and the legislature, there is what we call the miscellaneous benefit personnel fund, which is used as a fund to augment items which Congress may realign so that the budget is preserved.
Actually, I'm familiar with that, Secretary Drilon. The MPBF to, no? And this is actually a fund available to all parts of government, correct? Meaning it can be used to actually cross-border.
Yes, it is available to all the branches of government, but principally administered by the President and the Budget Secretary.
Yes. But again, I guess that's a conversation for another day. But I called you, Senator, so that I can pick your brain. I want to know the legislator's point of view. So if you don't mind, upon receipt of the proposed budget from the President, the deliberations are made in the House of Representatives, correct?
That's correct, sir.
And these deliberations are facilitated by the House Committee on Appropriations.
That's correct, but with one qualification, sir.
Yes, sir.
As soon as the budget is received by the House, the Senate would also conduct hearings simultaneously in order to prevent a delay. But no formal action is taken until the Senate receives the version of the House.
So there is a discussion in the House, and then they come up with plenary, and then they come up with a General Appropriations Bill approved by the plenary, and at that time, they convert it into the GAB, and then it's sent to the Senate.
The Senate gets the GAB, or the General Appropriations Bill, which is the official document which empowers the Senate under the Constitution to start deliberating on the budget.
In your experience, Senator Drilon, how much time does the House of Representatives spend deliberating on the NEP and converting it to a GAB?
Usually, if my memory serves me right, sir, the General Appropriations Bill would be received by the Senate about the first week of November. Just a very, that's how I recall it. So that by the first week of November, technically the General Appropriations Bill is officially with the Senate, referred to the Committee on Budget, and deliberated upon.
So, when the President delivers within 30 days from the SONA the President's budget to the House of Representatives, that is sometime latter part of July or August, and the House of Representatives has August, September, and October to do their own deliberations. Am I reading the math correctly?
More or less, yes, that's correct, sir.
So that Senate gets it in November.
That's correct, sir, to my recollection.
And then the Senate conducts its own hearings on the GAB, led by the Senate Committee on Finance. Am I correct?
with a little qualification. The hearings are already done even without the GAB being physically being transmitted to the Senate, although it is not officially called hearings on the GAB because the GAB is not yet with the Senate.
Yes. So, as early as August, Senate will already be talking about it, even as it has not received officially the GAB.
That's correct, sir.
So that's a period of 3 months for the House of Representatives, and for the Senate, a period of 5 months studying the proposed NEP. Am I correct?
Yes, Your Honor.
Okay. And then, so that will be, when does the Senate approve its final version?
The Senate would approve its final versions about the first week of December, if I recall correctly, sir.
And then that is when that document is thrown to the BICAM.
That's correct, sir. That is when the General Appropriations Bill is deliberated in the BICAM.
And the function of the BICAM, according to the rules, is to reconcile any differences between the version of the House and the version of the Senate. That's correct?
In theory,
In
that
theory,
is correct.
yes. Okay. And in theory, Senator President, how long does it take for the BICAM to reconcile the conflicting provisions?
In theory, that the BICAM is supposed to reconcile the conflicting provisions. But in truth and in fact, the BICAM is the third chamber of Congress.
From my earlier question, Senate President, it is clear to me that the executive's budget preparation would include questions already as to the readiness of the PAP for implementation, the absorptive capacity, and whether the PAP aligns with the PDP. My question to you is, how about for Congress? What do you look for, or what do you usually look out for in the budget?
Basically, the same issues that will be looked at by the cabinet when they on the preparation stage of the budget. For example, when the DB, the Development Budget Coordinating Committee, would brief the Senate, it would basically be the briefing that I would like to think is presented to the cabinet when the budget is prepared.
I'll be more specific. As a legislator, sir, what factors do you look at when you make a decision to reduce or increase the budget for a particular PAP?
Okay. One factor is budget utilization. To what extent is the agency able to utilize the budget given to them by Congress?
That's absorptive capacity.
Absorptive capacity, sir.
But when it reaches your level, don't you have an assurance already that through these 7 months, the executive has already determined that such an amount can be absorbed by a particular agency?
Yes, sir, but the senators would have their own judgment and their own theory as to the answer to that particular question. And they will ask that question, whether or not, in other words, the senators and the members of Congress have every right to inquire as to the correctness of the assumptions made in the budget.
And when you are not satisfied with the explanations of the executive, that is when you decide to either reduce or increase.
Among others, sir, because policy issues can also come in, which policies can be pursued with the appropriate budgetary support.
Have you ever encountered a situation where Congress makes a decision to completely defund an existing PAP or to delete a PAP?
Off the top of my head, yes, sir. I would not discount the possibility that the budget or Congress would completely disagree with the cabinet on the matter of pursuing a particular project or pursuing a particular project or program. And depending on the extent of the disagreement, the budget would be affected in terms of how much should be allocated.
So that is the check and balance.
That's correct, sir. Part of it.
But
Yes.
when you do the check and balance, you are still at the back of your mind, still aligned with the priority development programs. It is not simply, wala yan. Iba
Well,
yan.
sir, the development program, in crafting the development program, Congress has no participation. And Congress is the policy-making body. Therefore, it is not unusual for Congress to put in what they feel should be the policy thrust of the government, because under our system of government, Congress is supposed to be the policy-making body. And in pursuit of that policy, Congress appropriates funds. And that's part of our check and balance. If the president does not agree with that policy thrust of Congress, they can veto, or he can veto, that particular item.
In the same manner that you can defund.
In the same manner that we can refund. Defund, I mean, sir.
In your experience, I'm really getting your experience. Have you had situations where Congress decided to add conditions to the implementation of a PAP?
Yes, sir. I just could not recall a particular program or activity, but that would not be unusual to add conditions for the implementation or release of funds pursuant to a program or an activity in the budget.
In your experience, again, have you ever encountered Congress or Senate transferring PAPs from program to unprogram?
During my time, sir, there may have been transfers, but it is that significant that would catch the attention of the executive branch. There is, we cannot isolate the two branches altogether. As we all know, there must be an interplay of these two agencies. So there are occasions where we do what the good justice is saying.
Have you ever encountered situations where Congress or Senate would insert entirely new PAPs?
Candidly, yes, sir. But again, not of the magnitudes that we saw for the last 3 years, so that the general thrust of the president's budget is not affected by these so-called insertions. I admit before this honorable court that Congress do insert, but that is justified as in support of a policy thrust that the member of Congress would want to put across.
So they do.
They
Insert
do. We
new.
do.
They
I
create-
admit we do.
Even if these new PAPs never underwent any kind of study. And I'm trying to understand,
Yes.
is this a wish list? Or
Yes.
is this a situation where there are in fact programs with activities already that have not been prioritized by the executive, and therefore it is now the power of the legislature to put them back?
Let me state my own experience so that I do not ruffle the feelings of others.
Opo.
When I was doing projects in Iloilo, I inserted funds to support the project. These projects were not in the program of the executive branch. When I built roads, they were not in the program of DPWH. But I did insert. And to me, sir, I maintain the proposition with all due respect that insertions are not illegal. It is in the implementation of the insertions that questions arise.
But sir, I guess the thing my head can't comprehend is that do we have a situation where congressmen or senators will just have wish lists in their head and then say, I want a bridge there, I want a dam over here, and there is no study whatsoever that underlies all of these projects?
Well, yes, sir, because the member of Congress will assert that I have the mandate of the people to do this and do that. And number two, it is always the position of the congressmen and the senators are, we can propose policies as members of the legislatures, and these policies can be supported by funds which we will include in the budget. And by the way, sir, this is not a monopoly of the Philippine Congress. Every legislature all over the world would have a similar practice. That is why we call it a pork barrel. Why? It originated from the American practice of bringing pork in a barrel to the constituencies.
All right. Okay. I hear what you're saying. But the budget is a zero-sum game.
Yes.
So when a legislator says, I want this activity, project, or program, obviously it will necessarily defund another. How does Congress now choose which program, activity, or project will be defunded to fund the new one?
That's in our system, whether you like it or not, sir, that's a prerogative that the members of Congress feel they have because of the mandate they got from the people.
As a lawyer, sir, do you maintain that?
As a lawyer, sir, I don't see anything unconstitutional about that.
Okay. So, just to be clear, in the power of the purse, I'm trying to understand the contours of the power of the purse. The power of the purse, as far as legislators are concerned, number one, you are not beholden to the development plan of the executive, is correct? And number two, that you have your own opinion on where the country should go, what projects should be built, and therefore you provide for them in the budget. You supplant some projects, activities, and programs of the executive. Do I understand this correctly?
It is our humble submission, Mr. Justice, Your Honor, that the executive branch would not have a monopoly of what a policy should be. And that is precisely why you have a system wherein you have the executive and the legislative having to interact with each other. And having said that, Congress would have the power to appropriate funds in order to pursue a policy. Because that's how it works. In my humble opinion, sir, in my humble submission, that is how it operates. In the same manner, the same question can be raised on the budget secretary, on the DPWH secretary. The authority to decide where the bridge should be situated is a policy issue, where Congress has also the right to participate. If you put a bridge from this point to another point, does that serve the economic interest? And does that serve progress? And the congressman, sir, will argue that I should know the situation on the ground. And as a matter of policy, it should be from point C to point D instead of from point A to point B.
Even if that question of whether the bridge should be here or there should have been taken up at the RDC level, even if the senator or the congressman would have a say on where that bridge should finally go.
Theoretically, sir, the RDC does not work that way. The RDC on paper includes members of Congress.
That's right.
But in truth and in fact, the RDC meetings are only basically attended by the executive branch and the private sector, not members of Congress. That is the situation on the ground, sir.
Okay. Thank you, sir.
Thank you,
I
sir.
am enlightened. Salamat po. Tapusin ko na lang. Can I call the Solicitor General again, please? Thank you, sir. As a preliminary matter, in the April 21 oral arguments, I asked you to submit itemization for the 2024, 2025, 2026 projects covered by the support for foreign assisted projects. Have you submitted that?
Your Honor, may I confer with my team if we submitted that? My team confirms that we submitted in our compliance dated June 2, Your Honor.
Did you also submit the GOP peso counterpart for any FAPs in the 2024 to 2026 GAA?
Yes, Your Honor.
Okay, thank you. Just so we are clear, Madam Solicitor General, you also represent Congress, correct?
Yes, Your Honor.
Okay. So before anything else, have you furnished the court with copies of the 2024 to 2026 NEPs?
Yes, Your Honor.
What about the GABs as approved on third reading? Did you furnish us copies of those?
Yes, Your Honor.
All right. Did you also furnish us copies of the 2024, 2025, and 2026 bicameral conference committee reports?
Yes, Your Honor.
All right. At this point, can I ask the screen to show the bicameral committee conference report of 2024? That's part of your partial compliance, correct?
I would suppose so, Your Honor.
So if you see on the screen, the report is structured to show the increases and decreases that were made in the BICAM and the net change amounts indicated therein. Do you confirm that? Those are circled in red, I think.
Yes, Your Honor, although I could not really see the figures clearly, Your Honor.
Okay. I'm referring you to column number 3 under the caption decreases in parentheses. It shows a total of 564,459. This is from the program. The way I understand this is that this amount was taken from specific programs, activities, and projects under the total program new appropriations. Can we agree on that?
Yes, Your Honor.
Okay. I'm calling your attention to column number 2 under the caption increases. It shows the very same amount of 564,459. The way I understand it is that there are specific programs, activities, and projects that were either increased or inserted at BICAM level. Do we have the same understanding?
Yes, Your Honor.
In other words, since they're the same amounts, ang intindi ko dyan is kumuha from program at nilagay sa ibang PAPs that either were already existing or new ones. Is that a fair conclusion to draw from that? They're exactly the same amount.
Yes, Your Honor.
Okay. Ngayon, let me ask, are there documents that support the bicameral report? I mean, where do these figures come from? Are there supporting documents to all of these things?
This is the only document. My understanding is that this is the only document that was furnished us, Your Honor.
And since you're counsel for Congress, you can ask for this, correct?
Yes, Your Honor.
So can I ask for all those documents that support the bicameral committee conference reports. Yes, sir.
Mr. Justice, the bicameral conference committee report is the report itself. As flashed on the screen, this is the report. There is no narrative if we are looking for a narrative.
No, I'm looking for the details of those PAPs that were taken from program and put in other program. Those are the details I'm looking for.
I wouldn't know, sir. That is a matter which the administrative staff of both houses would be able to provide.
That's what I'm asking, the Solgen. Since you are counsel for Congress and you have committees that headed these things, so there would be reports that support those.
Your Honor, my team relayed to me that it has been previously requested from Congress, and that as Senate President Drilon is manifesting, that this is the only report that they are able to furnish us. This is the only report that they have.
You mean the Supreme Court can ask?
What I'm saying is that Congress says that this is the only report, and
Yes,
there are no other
But the question now is,
official documents.
where are the documents that support the figures in those reports? Because you've transferred PAPs. And according to Senator Drilon, that's within the discretion of Congress. Fine. But we would like to see what PAPs were defunded, what PAPs were created, and whether those new PAPs, what's the status of these new PAPs? Those should be in reports substantiating that conference report.
We will ask again, Your Honor, but I am not hopeful because we already asked previously for details.
Are you saying that there are no details or that they don't want to give us the details? They're two different things.
My appreciation is that this is the only document or report that they have.
There must be... Nagtanggal sila ng pera sa PAPs. Nilagay nila sa bagong PAPs. Hindi natin malalaman kung saan ang tinanggal nila. Kasi the NEP came from you eh. The NEP came from DBM. Therefore, DBM can just look at the GAA, compare it with their NEP, they can identify which PAPs were...
Okay.
Diba?
Yes, Your Honor.
And then you can see which new PAPs are in the GAA compared to the NEP.
We will ask again, Your Honor, as regards the PAPs that will support and what exactly did they approve in the BICAM.
There's a House Committee on Appropriations, right?
Yes, Your Honor.
And the Senate Committee on Finance.
Yes, Your Honor.
They have technical working staff.
Yes, Your Honor.
In fact, in one of the cases where they accuse government of filling in blanks, that was the technical working group that was supposed to complete that document, right?
Yes, Your Honor.
So they have the documents.
We will ask again, Your Honor.
Thank you. Hold on. Okay. I actually printed them out. These are the documents I'm going to be asking from you. Marife, can you give to Solgen and to the other petitioners? As well, Madam Solicitor General,
yes,
for those new PAPs that were inserted, I understand, I want to know whether or not they were implementation ready. So if they were implementation ready, if you can give me the feasibility studies, everything that was required by the NBM as to support those PAPs, new PAPs.
We will ask, Your Honor.
Okay. So, can I ask Yusek again to stand beside you? I just have a few questions for Yusek. And- Hello once again.
Good afternoon, Your Honor.
I'd like to ask lang additional questions on the release of funds for unprogrammed appropriations that have been triggered. Once the trigger is triggered, it is my understanding that the agency must submit a special budget request together with budget execution documents. And the budget execution documents are the financial plan, the fiscal plan, and monthly disbursement program. Am I correct?
Yes, Your Honor.
Okay. How do you validate that these documents are not gawa-gawa? From the DBM's perspective.
Number one, sir, we compare also with the financial and physical, well, with the reports that they are submitting to us. But in case of evaluation and they feel that based on the paper something is need further questions, then we validate with the agency.
Pero itong special budget request, well, hindi ito mga dokumento na nagpapakita whether or not that particular project, activity, or program is ready to be implemented.
It should be, Your Honor.
It should be.
It should show. It has no particular format, but one of the requirements is to establish whether or not they are implementation ready, so that we can recommend them for clearance by the Office of the President.
Okay, so any item in the unprogrammed funds portion. I'm talking about unprogrammed.
Sorry, Your Honor. I was talking about the congressional increases and adjustments. For the unprogrammed appropriations, that would also cover the implementation readiness as well, Your Honor. But they will not require the approval of the Office of the President.
Yes, pero at the DBM level, an agency makes a request, a special budget request. That's addressed to you, di ba?
Yes, Your Honor.
And then, the way I understand it, kailangan ng ibang budget execution documents like financial plan. This is for the unprogrammed funds, di ba?
Yes, Your Honor.
Does DBM satisfy itself na, oops, okay, ready to be implemented na itong project na to sa unprogrammed? Do you do that vetting process? I guess is my final question.
That is the expectation, Your Honor. I am sorry because I am not the one who is doing it, but that is the expectation of our bureaus that are conducting the evaluation.
And what bureau is that?
That would be the various bureaus, budget and management bureaus A to F. So they have different coverage depending on the sectors. For example, if DPWH is Bureau A, earlier it's C, it's for GOCCs, B.
This is where I'm coming from. I seem to recall watching Engineer Alcantara in the flood control mess. No? He was saying that kapag nalaman na nilang na-approve na yung unprogrammed, yung project nila sa unprogrammed, dun lang sila gagawa ngayon ng mga plano, kukuha sila ng litrato, tapos, in other words, gawa-gawa. Diba? And when they submit that, para lumabas yung pera, kasi sa inyo manggagaling yung pera, di ba? Paglabas niyan, bago lumabas yan, ano ba ang ginagawa ng DBM? Tinitignan nyo ba talaga yung mga dokumentong yan? Sinusuri nyo ba? Anong klaseng pagsusuri ang ginagawa nyo? Or nandun lang yung caption, special budget request, tapos may picture, tapos merong drawing, tapos release na kayo. What does DBM do?
I have no personal knowledge, Your Honor, but my expectation is it's up to the level of the request, but not up to the nitty-gritty as to the engineering, as to the nitty-gritty details of the project. But it's up to the level that our bureau is convinced that the project is implementation ready based on the representations of the Secretary of the DPWH.
That's why Yusek, in the beginning, I went with you through all the process, di ba? So lahat yan, makikita natin, DBM is always on top, it's always, may assurance kayo because you were part of that process na implementation ready yan.
Yes,
Pagdating sa BICAM, nag-iba. Suddenly, meron kang project, activity, or program na napasok sa unprogrammed part na hindi, alam ninyo, hindi siya implementation ready kasi hindi nga pumasa sa inyo eh. Or totally new, di ba? And I'm coming from your statement that everything in the unprogrammed funds should be implementation ready. So, since alam ninyo itong PAP na to na nandun sa unprogrammed ay hindi nanggaling sa NEP ninyo at pinasok lang sa BICAM at suddenly hihingi sila ng pera to draw that fund, ano ang ginagawa ng DBM?
They would submit the same documents, similar documents that are required when we do the budget prep.
Ano yung mata ng DBM? Are you the gatekeeper? I mean, how do you look at it? Shouldn't you be the gatekeeper and say, bakit pareho ang picture nito dun sa ano? You know what I'm saying?
Up to the level of the request, Your Honor, we actually exercise prudence in evaluating, but not as to the last details.
There is no group in DBM that actually, again, ang premise ko, alam ninyo, hindi galing yan sa NEP eh. Galing yan sa BICAM. Tapos may project. Tapos billion. Wala bang tao sa DBM that will actually, vet it in a way na, totoo ba tong planong ito? Totoo ba talagang may ganyan? I want to know how it works eh.
Unfortunately, Your Honor, not to that great lengths. I could say it is more of a desk audit of the papers, the documents that were submitted to us. And we are also relying on the ultimate responsibility of the head of the agency when he requested and made representations. Unfortunately, Your Honor, if we look or validate each and every detail of the request, we are not really very able, meaning as to number and the volume of the projects as well as the technical understanding.
Understood. Thank you, Yuse. Final question ko na lang kay Soljan. Clear from my questions that it takes 7 months for the executive to come up with a NEP. It takes another 3 months for the House of Representatives to go through the GAB, to come up with the GAB. And during that same period, plus an additional 2 months, the Senate discusses the GAB after ratification. That's almost a total of 10, 11 months. And then the BICAM deliberates on it for only 13 days. 13 days. And in that span of 13 days, the BICAM identifies new PAPs worth billions of pesos that it deems more deserving of funding than those proposed by the President. In that same period of 13 days, the BICAM members are able to evaluate the merits of these PAPs, they're able to satisfy themselves that these PAPs are implementation ready. They're able to tell themselves that they can be performed by the appropriate agencies. Does that make sense to you?
It seems, Your Honor, that with the amount of time that the executive would put into the technical planning, it seems that the period of time by which Congress or the BICAM puts into its conclusion, collapsed in 13 days, would be far shorter, and it doesn't seem reasonable to our minds. However, it is our position that that is actually part of the constitutional design.
The BICAM is not in the Constitution.
Sorry, by BICAM, Your Honor, I would refer to the action as an action of Congress because the Congress signed the BICAM report and passed it into a GAA. And based on the constitutional design of our constitutional democracy is that really the checks and balance have to be that the president is the one that proposes, and under Article 6, Section 25 of Paragraph 1, the instruction of the Constitution to Congress is that just to observe the sealing and that the form, content, and manner of preparation shall be prescribed by law. So if the Constitution intended for to recognize the technical expertise of the executive, then I would surmise that it should have lodged the power of the purse as well to the one that is able to give the technical planning. But it isn't so, and it was given to the Congress. The power of the purse is given to the Congress. So with regard to is it sound, is it reasonable, I think it's, we could agree that...
What you're saying is, it is what it is.
Yes.
That's what you're saying.
What I'm saying, Your Honor, is if we look at the legal framework, I think that is what is intended to be the design of the separation of powers.
Is it your position, Solgen, that the separation of powers prevents the Supreme Court from having a say on the validity of what the BICAM does, given that it only has 13 days? Remember,
yes,
I'm all for separation of powers, but are we saying, what are we saying? That the Supreme Court has no power at all to actually say that the BICAM process is infirm, that the BICAM report reeks? Is that what we're saying? The separation of powers prevents us from actually going there?
Your Honor, the position of the Republic is just for the consideration of the court. With regard to the separation of powers, we're trying to identify the constitutional limitation that is imposed on the respondents. What's the limitation imposed on?
That's why my questions focused on the BICAM, which is not a creature of the Constitution. Yes, you can tell me it was signed anyway. It is what it is. And the reality is, how much time does Congress really have to study insertions made by the BICAM?
Yes, Your Honor.
And I just can't accept for now the proposition that in the face of all of these things, the Supreme Court cannot say anything about it because of the separation of powers.
Your Honor, it is our humble submission, and we included it in our comment. We provided the ruling of the Supreme Court in Tolentino versus Secretary of Finance on the enrolled bill, and that whatever doubts there may be as to the formal validity of the RA that's involved there, which is 7716, must be resolved in its favor. And if I may read, our cases manifest firm adherence to the rule that an enrolled copy of a bill is conclusive not only of its provisions, but also of its due enactment.
Sorry, what are those cases again?
Your Honor, it's the Tolentino versus Secretary of Finance.
Decided by the Supreme Court?
Yes, this is decided by the Supreme Court.
And we can reverse it, being the Supreme Court, right?
Well, yes, Your Honor, it is within the power of the Supreme Court to revisit if it feels that their circumstances now are different, and if it feels that, or if it thinks that certain rulings in the past have to be revisited, Your Honor.
Thank you, Solja. Thank you so much.
Thank you very much.
Thank you to Amici. Thank you to USEC. Salamat.
Thank you, Chief Ben. Go ahead.
The Solgen, before we adjourn, just for our curiosity, the case that you cited on the enrolled bill, what date was that? Tolentino versus, it was the Tolentino case. It was, according to our memory expert, 1995 GR number.
1994, Your Honor.
1994, okay. Now, just to explain to you, we do not call all cases for oral arguments. There are only some cases which we call for oral arguments for the public to see the way we think about certain issues and for us to explore before we make a decision. I think the point made a while ago by Justice Ben Kagiwa with respect to the attachments or the supporting documents on the Bicameral Conference Committee report is very salient for one issue that is cropping up right now, which is the discretion of the Bicameral Committee with respect to appropriations. Specifically, he pointed out 2024, when the GAB and the Senate version were consistent with the NEP, but there was an addition of about 400 or 500 billion introduced by the Bicameral Conference Committee. Now, we want to be fair to all the parties, and this is the reason why we are asking for the supporting documents. Not only to the parties, we want to be fair with respect to our duty to the public in general, that when we decide, as you saw in the line of questioning of the justices a while ago, that when we decide, we give all considerations to everything. Therefore, in addition to the documents requested by Justice Ben, kindly request from the House and the Senate, your clients, whether there are supporting documents, once and for all. And here, we need a certification that there are no supporting documents, if there are none, for the Bicameral Conference Committee report. And if there are none, an explanation as to how they arrive at the increases and decreases, because what we saw collectively was that there was centavos at the end. So we want to know how they are computed and why there are no documentations. So that is all for now with leave of court, in addition to the requirements. The petitioners are free to also comment, because you do have members of the House with you. In fact, the various petitions and one of the councils have been a member of the House also. You're free also to make your own manifestations. That's all, Chief, for today.
Yes, Your Honor, we will comply.
Thank you very much, Sarge. So as not to interrupt the flow of interpellation, we'll adjourn today's session and resume on July 14 at 9:30 a.m. Attorney Maripe, are there any other matters?
There are no other matters, Your Honor.
There being no other matters, session is adjourned.
Please rise. Please remain standing while the Chief Justice, the Senior Associate Justice, and the Associate Justices leave the session hall.